Morning.
Good morning. How are you?
All right. Seems like lots of people are piled up outside.
Yes. My buddy Rio, she called.
Okay.
My goodness.
Good morning.
Hello, Josh. How are you?
Sorry you guys were stuck out there.
It's all good.
Morning.
We were outside. Yeah. Wow. See, the hair on top, just get it.
Phones to be on silent and put away. The phone, put away.
All right. Why don't we get started? We have a criminal trial calendar, 2-week calendar, 2 weeks of trial starting next Monday. And I will go through the calendar so we can get the latest announcements from the lawyers. The expectation is that positions 1 through 4, all co-defendants, would be a trial that starts on Monday. It was specially set for Monday, although I've heard rumors that maybe some of the cases or defendants are working the case out. We'll need Mr. Abate for that because I see a couple of the defense attorneys here. Is he working his way this way, Ms. Davis?
Should be, Judge. I will text him.
Okay. Well, I'm gonna get through the calendar and then we'll see how we can fill the day. We've got all day to work through things. I have to stop at 10 to be on a Zoom call with the sheriff's office for about 15 minutes, but maybe that will be when lawyers are pre-trying things. And then 10:20-ish, we'll pick back up, and then we'll go till we take a lunch break. And then if there are more pleas for early afternoon, we can do that as well. Position one is, well, before we dive into that, are all the inmates here, Deputy Gordon, or were there some who were not produced?
I think one is not here. Position 13, William, Giffen, Ariel.
Oh, he pled.
He pled, so he should be somewhere else.
Yeah.
All right, excellent. So position one is Michael Ryder. Good morning, Ms. Feely. Nice to see you again. What is your announcement?
So I was hopeful that this would work out. I spoke with Mr. Ryder on Tuesday at the jail with a more detailed offer, and he was not wanting to enter a plea on Tuesday. I'll be able to get today, obviously, but
Okay.
so that's where we are.
Great. Well, when Mr. Abate gets here, you and he can talk, and then I'll certainly engage with Mr. Ryder. I want to get on the record whatever the offer is, so that if he says no, thank you, it's eyes wide open that he's going into a murder trial and not a shoplifting trial. All right. Thank you. Position two is Eric Lemons. His lawyer, Ms. Cabrera, is in trial next door. So I'll hear from Mr. Abate about what's happening there. Mr. Regis, your client is Desmond Hardy.
My expectation is that that will be a resolution.
Okay, I like the R word, whatever it ends up meaning, but I guess we'll need your counterpart, Mr. Abate, here.
Yes,
Okay, are you available most of the morning? I'm glad you're here, and I want to make sure we use your time before you get whisked away somewhere else.
I'm here all day until 9:30.
Okay, till 9:30 a.m. or 9:30 p.m.?
I'm here all day.
Excellent, okay, so I got more than 17 minutes. All right, well, hopefully we get the prosecutor here. Your client is up, so if you need to engage with him, once I call the calendar, Deputy Gordon can get folks back there. Okay, you're welcome. And then the fourth defendant is Mr. Robinson. His lawyer, Ms. Bumpus, will be here. She sent an email saying she's running a little bit late, so we'll get her announcement, although her email said that it is resolving also. I think she used the P word rather than the R word, but either way, that's close enough for resolving to me. Position five is Troy Britton. She's also position 9. Is Ms. Britton here? Okay, do you expect Ms. Britton to be here? You've tried to speak with her, but have been unsuccessful?
Yes.
Okay, well, we'll give her a little bit of time. If she doesn't make it, then we'll do a bench warrant. When did you last speak with Ms. Britton? Has it been months, or I know we had something she had to miss because there was a medical issue?
To get that.
Okay.
information, and then a day after, I know she still was not feeling well.
Okay. Okay. All right. Well, I think maybe her co-defendant has a channel into her as well, but we'll see if he's here. Is Mr. Palmer here? That'll be 2 for 2 in that case. All right. I'll call those names again after we get through everything. So Mr. Palmer has 2 cases and Ms. Britton has 2. They're not the same 2. Next up is Brenton Dennis, and I saw Mr. Bass here. There he is. Good. Good morning, sir.
I intend to make the same announcement I have been making. I'd like 90 seconds with Mr. Abadi prior to that.
Excellent. He'll be here. He's popular this morning, so do talk with him. My thinking is this is a case we do week 2 of this 2-week trial calendar, but we'll talk after you've spoken with him. All right? And your client is here, so if you need to talk with him or he needs to come out here, we can do that. Kwame Harris resolved his case. Brandon Baker, his lawyer is in trial. Larry Williams resolved his case. Joel Lett. Mr. Lett, good morning.
Good morning, Judge. Duvernay on the Zoom.
Good morning. Thank you for calling in. I know you're on leave. I just wanted to make sure we touch base on what we're doing with this case.
Yes, Your Honor. We're still trying to work through it. I think if you recall, we had a private conference with me, you, and the state about Mr. Lett and some of his underlying mental treatment. I need to update myself and the team with what's going on. He has been getting treated for the past several months. I will let the court know that on the second week of the trial calendar, I am on leave. I'm not, and I received several notices from the state that they were on leave. I don't know if that was for today or during the trial week. So I don't know what the state's position is at current. This is something that I would love to work out eventually, but I don't know that we're there yet, Your Honor. I haven't received an updated offer, and the last offer did require him spending several years in confinement.
Okay. Ms. Davis, has this become your case?
It has been, and I thought that I emailed Ms. Hill. Maybe I have the incorrect email.
Ms. Davis, you may have. I've been in a crazy trial prep and I've been on
Okay.
leave. So if you've emailed me in like the last several days,
Yes.
then I will stand corrected. But prior to the last several days, I had not received an update. So my apologies, Your Honor. As you know, I'm on leave now. And I try not to be a workaholic. So if it was sent while I've been on leave, then my apologies to Ms. Davis.
That's okay. You've been on leave. I mean, I thank you for apologizing to her. Your leave letter, it's interesting. It's dated April 28th, but it didn't get filed until July 1, which is after the trial calendar was published. And I flagged that not to say, so I'm not honoring the leave, but it's explaining why we put this on the calendar and we're expecting people to be here. It just got into the docket a little late. And so I'm sure Ms. Davis has been working the case up with the expectation that it might be reached. I
did contact my staff about that, Judge, because they've had those dates since April 28th. And so trust my legal secretary was heavily reprimanded for not getting it filed when I told her to. So my apologies on that.
That's okay. I don't want anyone to be heavily reprimanded, but next time
she's still got a job, Judge.
Okay, good. She's not on the unemployment rolls.
Right.
Okay. So what I am willing to do is move, given your leave and Ms. Davis's leave, is to move this to the August trial calendar, but that'll be its final stop. And as I'm looking at your leave now, it just goes through August 1, not beyond that. Is it safe to say you're available in the month of August?
Yes, Your Honor. I'm fully committed. I usually try to take some vacation during the summer, but I get right back to work in August. So whenever you reach us in August, we'll be ready if we aren't able to work something out in the meantime.
Got it. Okay. I'm curious, your leave the last few days, end of July, beginning of August, says religious observation. What is the religious holiday that falls in those days?
So we're Pentecostal and we have our annual convention. And so we go for a whole week. We're going to be in New Orleans, singing and shouting and eating beignets.
Excellent. That sounds like a wonderful religious observation. I wouldn't have linked New Orleans with it, but that's great. The group here is jealous of you, but that means you're going to be recharged and full of good faith. And we will see you on that August trial calendar. Before you go, Mr. Lett, do you have any questions? We've been talking just structurally about your case and what we're doing next. And your lawyer, I didn't realize your lawyer had this leave. Her letter was from April, but it just didn't get into my files until July 1 after we had published the calendar. So I don't usually make folks come down here for no reason, but it was brought to my attention yesterday, this leave, but I wanted to make sure I laid eyes on you. You doing okay?
Yes.
Okay. You will be back here for our August trial calendar. If your lawyer is able to work something out with the prosecutor that you're agreeing to as well, we'll resolve the case that way. Otherwise, your lawyer and you should be ready to go to trial in your case in August, okay? Any questions about anything? No, your consultant doesn't have any questions either? All right. then you are good to go. And thank you, Ms. Duvernay, for joining us during your break. You should go back to your break now.
Yes, Your Honor. Thank you. Have a great day.
You too. Bye-bye.
Bye.
Thank you.
You're welcome. Robert Holliday, position 15 and 16 is next. Ms. Wood, you remain ready on his cases?
Judge, I will speak with him to see if anything's changed.
Okay, and Ms. Davis, my understanding is that position 15 is the one that the state, someone from the state would be ready to go on next week. Okay, great, thank you. Terrell Stokes. Good morning, Mr. Stokes. I think we have a plea in your case. So we'll do that this morning, whether it's before 10 or not, depends sort of how things flow, but ready on that one. Darshawn Taylor, I think that's diversion. Did I already sign? That's one that you did get the green light on? Okay,
Signed the
so that's
order.
been signed. So that's on judicial hold. Jamarius Favors, the guy who just walked in? All right. Hey, Mr. Favors. Hey, Ms. Rios?
We're ready on it.
All right. Sounds like you're working both cases. There's this non-complex one.
That is going to be judicial hold and then close once he completes the other case. I emailed about it of what we'll be working on.
All right.
Upon the successful completion of all the requirements.
Got it. It's sort of like that one is being diverted. Function, I mean, it'll be on judicial hold. If things go well for Mr. Favors on the case we've got, then that other case, the state will null pros. Okay.
Take it out of the current judicial hold, because that's where it's for, and then put it into this temporary.
Well, we'll work through all that when we turn to Mr. Favors's cases. All right. How about Ms. Bernard Taché? And I apologize if I'm mispronouncing your first name. How do you say your first name? Taché. I was close. Ms. Bernard, your lawyer, Ms. Cabrera, is in trial right next door. And we're hoping to get a few minutes of her time this morning so we can figure out what's going on with her various cases, one of which is yours. Do you know, have you, Ms. Davis, had any communications with Ms. Cabrera about Ms. Bernard's case?
I have. It was my understanding she was trying to contact her and was not able to make that connection.
Oh, okay.
To update her with the offer.
All right. So you should sit tight, Ms. Bernard. I'm not going to forget that you're here. Please don't leave. You can leave to use the restroom. Don't leave the courthouse until I've said it's okay to go. All right? Michael Ross, another Cabrera case. And that's one where maybe diversion.
Yes, he was accepted into diversion. Again, she hasn't been able to communicate with him, but I wasn't sure if Mr. Ross was still in custody from his other.
He's here.
That's probably why.
Okay, so we'll see if we are fortunate enough to get some Cabrera time today. Half the calendar. Mr. Martin Pled. Jillian Nelson, I think is, hello, Mr. Orlady. I think we have Mr. Nelson. Is he at Dooley?
Yes, Your Honor, the Dooley State Prison.
Great, there he is. What are we doing today?
We have a negotiated plea of the court's ready.
All right, we will do that one first. I know that there's some other folks who said, I'm so ready, but we have the good graces of GDC getting Mr. Nelson here. So I'm almost done with the calendar and then we're gonna do that plea.
Perfect. Thank you.
Okay? All right, Ms. Patrick, rolled, is Kiara Patrick here? Did you tell her she didn't need to be here? How did we handle that?
Yeah, okay, so it should be.
Okay. Bench warrant for Mr. Trujillo. Tyreek Gould. Mr. Gould? Were you expecting him?
Judge, the number I have for him, so we're in service.
Darn. We're moving these cases kind of quickly. All right, we'll see what happens. Mr. Elder pled. Claudine Hardison. Good morning, sir. Hey, we had talked about a virtual PTI-ish situation.
Yes, and that is how we're moving forward on this. I think we probably need to do an order. I expect he's already started working on those requirements.
Good.
I'm hopeful this will be resolved very quickly.
Okay.
So I think we should maybe just put on an inquiry bill.
Well, what I'd like to do is enter an order that looks a lot like what we do with the district attorney's diversion. You may have done one before. If not, Ms. Feely has a go by where you literally list, you send me the Word version of the order, but you list what all the requirements are so that it's something I said, you will do this. And if you do these things, then your case will be dismissed. And then we'll put it on judicial hold and put it on an inquiry calendar, however many months out. So if you just make sure Mr. Hardison is agreeing that the 5, the 2, whatever number of requirements, and then get that to me, copying Ms. Davis, that should take care of it.
Will do. Thank you, Judge.
You bet.
This is pretty good.
Does he know what all the pieces of the virtual PTI are?
We went through it all yesterday.
Okay, yep, Mr. Hardison, you're free to go. Demetris Davis is here, and that is the other case we might try week 2, unless anything new on Mr. Davis.
I'm gonna speak with him and Mr. Abadi today, Judge.
Okay, great. See what happens with that. Tacorius Rose. Good morning.
I need to speak to Mr. Rose and then I'll have an announcement before.
All right, Mr. Rose, you can take a seat. Ms. Wood's going to talk to you about whether we're sorting your case out today or not. All right? If not, we may see you on Monday for trial. Kendall Fields. Hello, Mr. Fields. Ms. Rios? A plea. All right, we will do that this morning. And then we've got Hassan Abdul, and we've got Ms. Hurwitz here for that.
Yes, good morning, Your Honor.
And I guess he's on for a plea and a revocation?
He has 2 violation of probation.
Okay, and Ms. Simpson sent me that info. It was a real old case, a newer case, a less old case, and then we've got this. And what are we doing today with, is it Mr. Abdul or Mr. Hassan? I've seen his name.
Mr. Hassan.
Mr. Hassan.
Both ways, Mr.
Okay, so what are we doing today with Mr. Hassan?
I have been in touch with ADA Davis. We are still working toward resolving, but I think we're very close, Your Honor. I filed a waiver of indictment on Tuesday. We had discussed the possibility of a brief reset just to make sure that all of the cases are on the same calendar.
So there's another, I'm sorry to interrupt. So there's 2 revocations, there's the indicted case, and then there's yet more conduct. There are 5 other cases? 7 other cases. Oh, these are all the second-degree burglaries. Yes. That's right. Ms. Davis flagged this for me, that they are going to seem very similar.
Yes.
Okay.
So we are just hoping to resolve everything globally, Your Honor. ADA Davis had mentioned some dates, potential dates. I think they were all within this month. It would be possible to put everything together.
Okay. I'm all for putting it all together. Ms. Davis, how much time do you need? Did Ms. Hurwitz describe sort of what you thought the plan was going to be?
Yes, Judge, she did. I will need time to, of course, obtain all the evidence in the cases just to make sure that it does warrant indictments for those 6 or 7 cases. I would ask for at least a couple of weeks. That way I could gather the evidence, review it, and then draft those indictments, get those filed with the green sheet so they can all be together.
And is there a way for you to be able to indict them all as one, or is it 7 different indictments?
And that's why I need to look at it, because when I reviewed the warrants, it just seems like it's a bunch of different warrants under each case, or some of them have basically duplicate warrants.
Yeah.
So I don't know that it is actually 6 or 7 cases, whereas it might just be 2 or 3.
Okay.
Based on the dates.
I don't get the sense that Ms. Hurwitz would be filing a motion to sever counts and this and that. If you want to, it may be that it's only 2 incidents and not 7, but I believe you can package it all into one accusation. If there's a waiver of indictment, if it's got to get in front of the grand jury, you can do that. But I think I heard Ms. Hurwitz say that she's either already done a waiver of indictment or she'll hand you one. And then you could just accuse it. And I think what would be most efficient, as long as it's not inconsistent with DA policy, would be once you figure out how many second-degree burglaries there are, just put them all in one charging document. And then we'll have a 25 SC number, 2 25 SC numbers, and then some revocations. All right. So then I guess you and Ms. Hurwitz can work with Ms. Nelson about getting a date in. It'll probably end up being early August because the next 2 weeks are trial calendar and you've got some leave. And then there's the annual judges reprogramming. And then we're into August. So it'll probably be early August. Is the sense of the resolution that Mr. Hassan gets out right away so that sooner is better, or he'll be in for a little bit longer so that if we just look for a good, safe, open date in August, we're accommodating everyone?
Yes, as we are going to be asking for some time. There may be some treatment involved, but we're going to be asking for some jail time.
Okay. Ms. Hurwitz, what are your thoughts about timing? It's not going to work to do it. Well, let me put it this way. The earliest we could do it would be August 1, and that's not going to be popular with Ms. Nelson. So it probably would be later in August, but it could be the week after.
Yes, Your Honor, in terms of dates, if we can approach at the end of the calendar.
Okay.
It would be easier, but we just wanted to talk to you.
Okay, that's fine.
Okay.
I'm always happy to talk about dates. Would you like Mr. Hassan to come out here, or I'm happy to engage with him if it's helpful for him to hear from a judge, but I don't need to do that. You'll be able to talk with him before you leave. He is here, he's up, and you'll have a chance to chat with him.
You can come out, that'd be fine.
Okay. Why don't we talk dates first so that before we bring him out, so that we're letting him know what the basic plan is? All right. We got one more case, and that's Mr. Chastner. I don't remember. I think I said he was, I know what we're doing with the case, but I said he's excused. Okay. And Ms. Davis, I think you were on that email chain, Mr.
Yes, sir.
Furlong and yet more time, and then he's got leave. So I think this had to bump all the way to September.
Correct.
All right, boo. Did you figure out work release or whatever with cases like this?
Yes, I don't think.
Not so much.
Work.
Okay.
No, and that's the news I shared with Mr. Chastner yesterday.
All right, happy day for him. Anyone here who didn't hear their name called? I've now called all the names on the calendar. So if you didn't hear your name called, you either came in late or you may be in the wrong courtroom. We good? Let me try one more time. Troy Britton. Mr. Palmer. We had one other.
I think it was
Tyreek Gould. All right, Ms. Davis, and we'll see if people walk in later this morning, but those will likely be bench warrants.
judge.
All right, I would like to please handle Mr. Nelson's case now, since he is on from GDC custody. Mr. Abate, you are back. You're here. Ms. Feely announced it's not worked out. Mr. Regis announced resolution, whatever that means, so you guys can talk. And Ms. Bumpus will be a little late, but she will be here. Her email said Plea. And Ms. Cabrera is next door, and we're hoping to get a little bit of her time. And then Mr. Bass said, well, he said he needed 90 seconds with you before he made his usual announcement, which I assume is ready. I told him it would be week 2 if we get to Mr. Dennis's case. But I just wanted to get you up to speed as to what was discussed about your cases. You're welcome. So if you can engage with some of those lawyers while we take this plea, that would be great. Yeah, they want to have some conversation about it, so I will.
That's what I was like, I usually don't put that in an email through, like, where the beat is not beat.
Yep.
Yeah, usually they do, but I think that one happened so quick, it wasn't a situation they had to prepare for. Especially because she was right there, she would have had a really good close up video, yeah. And surveillance, and I did follow up, I actually had asked that like 2 or 3 weeks ago.
Good. We'll stop whatever we're doing when she shows up. I have to stop at 10.
Yeah, you know what that means.
So we'll at least do this plea, and then it may be people can pre-try.
Yeah, I guess, right, like, someday.
All right, Ms. Davis, let me know when you are ready.
I am ready.
All right. Ms. Rivers, are you ready? Good morning. We're going to get on the record in 24 SC 005 957. That is State versus Jillian Nelson. Mr. Nelson, can you hear us? Yes. Okay. You're going to need to unmute because you will be answering a bunch of questions in just a moment from Ms. Davis. How are you doing this morning?
I'm doing great. How about you?
I'm doing all right. I can hear you well, which is good. Mr. Nelson, you are appearing from the Dooley State Prison. I need to make sure that you are comfortable waiving your right to be here in court and you're willing to proceed virtually from your location. Is that correct?
Yes, sir.
Okay. You also have a right to have Mr. Ololoye by your side to answer questions that you might have, but he's here in court. If you need to speak with him privately, we can make that happen. I don't think there's going to be anything that comes up that requires a private consultation, but let me know if you need to speak with him privately, okay?
Yes, sir.
Ms. Davis is about to put you under oath, then she's going to ask you a bunch of questions. If at any point you cannot hear us or you have questions about what you're being asked or you're just confused about something, will you let me know?
Yes, sir.
Great. Then let's get going. Ms. Davis?
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter before the court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Please state your true, correct, and legal name for the record.
Jalen Nelson.
Are you at this time under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 22. I dropped out 9th grade.
What high school did you attend?
Banneker.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you're charged with the following offenses in indictment 24 SC 005957, aggravated assault, riot in a penal institution, possession of a prohibited item by inmate, willful obstruction of a law enforcement officer?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to the charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer about all the facts and circumstances known to you regarding this indictment, including any potential defenses?
Yes, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Please tell me how to say your last name. Ololoye. Do you waive formal reading of the indictment and any and all defects therein for the purposes of this plea?
I do waive.
Thank you. Mr. Nelson, do you remember having been arrested on these charges?
Yes, ma'am. I was already arrested, but I remember those charges.
Thank you. The state is unaware, Your Honor, of any outstanding warrants related to this matter. Mr. Olaloye, are you aware of any outstanding warrants related to this case?
I'm not.
Mr. Nelson, has your attorney advised you the minimum and maximum sentence for each charge to which you're pleading to today?
Yes.
For aggravated assault, the maximum sentence is 20 years. For riot in a penal institution, the maximum sentence is 20 years. Possession of a prohibited items, the maximum sentence is 10 years. And obstruction of a law enforcement officer, the maximum would be 5 years.
Okay.
Do you understand that today you're entering a negotiated plea of guilty, which means the state will recommend a sentence to the court?
Yes, ma'am.
Do you understand the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that there are multiple charges to which you're pleading today, and the court has the right to run those sentences consecutively, which is one after the other?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including federal courts?
Yes, ma'am.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that is true regardless of any advice given to you by your attorney or anyone else?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'll be guilty of a felony, which may carry a sentence from 1 to 15 years in prison?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yeah, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury,
Yes, ma'am.
the right to remain silent and not incriminate yourself,
Yeah, ma'am.
the right to confront witnesses against you,
Yeah, ma'am.
the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case,
Yeah, ma'am.
the right to the presumption of innocence,
Yeah, ma'am.
the right to testify on your own behalf and to present other evidence,
Yeah, ma'am.
the right to subpoena witnesses and compel the production of evidence,
Yeah, ma'am.
the right to have the charges against you proved beyond a reasonable doubt,
Yes, ma'am.
the right to appeal if convicted of these charges after a trial.
Yeah, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have only 4 years from today for the felony charges to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
How do you plead to the charges in indictment 24 SC 005957, aggravated assault, riot in a penal institution, possession of a prohibited item by an inmate, willful obstruction of a law enforcement officer?
Guilty.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Can you ask that question again?
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Okay. Your Honor, we believe the facts would show at trial that on July 17th, 2023, at 901 Rice Street in Atlanta, Georgia, in Fulton County, that Officer Max Swain with the Fulton County Sheriff's Officer, who was assigned to the 6th South floor, was performing his duties assisting with commissary inside Zone 500. At that time, Officer McSwain witnessed inmate Nelson run out of the zone and attacked inmate Garner Adrian with a shank. It was a makeshift knife, and at that time, they radioed for assistance. The officer did have to deploy his taser to suspend the attack. And so the state is asking for 6 years to serve 2 years with the balance probated. We're asking that there be no violent, harassing contact with the victim, Adrian Garner, or if the court sees fit, the balance can be suspended.
Okay, got it. Ms. Jackson, good morning.
Good morning, Your Honor.
Can you share with me the information you've got on Mr. Nelson's criminal history?
Yes, there are 6 cycles. The last arrest was November the 10th, 2023 in Fulton County for possession of Schedule 1 controlled substance. That charge was dismissed on April the 1st, 2024. He does appear to be under sentence. That case number is 21 SC 180065 for a charge counsel may want to waive sounding on and aggravated assault and possession of a firearm during commission of a felony and criminal damage to property in the first degree. It's a 12-year sentence. That disposition date was February the 20th, 2024. Nothing in addition, Your Honor.
Thank you, Mr. Ololoye.
Yes, sir.
Couple questions and then anything you want to share about Mr. Nelson. I appreciate Ms. Jackson's discretion, but I'd like to know, I thought it was a voluntary manslaughter charge. We should just air it out. Mr. Nelson's in custody for, I guess, that case?
That is correct, Your Honor.
Okay. And he received a 12-year sentence?
I believe so, yes, Your Honor.
Okay. And he's been in custody for about how long?
I know this happened in July 17th of 2023.
Right. Mr. Nelson, how long were you at Rice Street?
4 years.
4 years. So you've done, and then how long have you been in the Department of Corrections?
I got to prison last May.
Okay, so you've done about 5 years of your 12-year sentence?
Yes.
What is pardons and parole telling you, if anything, about a potential?
I got some O's. I was talking to my attorney about that yesterday. Like, I really got finessed into some other junk with that. I don't know, like, what I took on that. I was young and dumb. I don't know about that. But what I know I'm doing right now, I know what I'm doing right now. Like, I'm taking a sit do too if y'all wouldn't know.
Okay. I think I'm good with it too. I'm just trying to figure out, has pardons and paroles told you yet an expected release date?
Nah, well, my PED, my parole eligibility date is 2020. I think 2025, December 2025 or June 2026. I know my PED date coming up, but you know the PED date is a new law that just passed where you only got to do 30%. But since my charge is so high and my charge was a murder charge drop, I got my charge dropped from a murder to a manslaughter. So.
Yeah.
When I went to Jackson, the parole board already told me like they probably gonna make me do most of the 12 years.
Okay. All right. I appreciate you sharing that. That's what I was trying to get at. I just forgot the term, the PED. So that's good to know. Mr. Ololoye, what else do you want to add? And was Mr. Nelson saying he has other holds?
No, Your Honor.
No.
He had other cases that resolved under that voluntary manslaughter.
That wrapped up a bunch of stuff.
Right. This is the only thing that was left.
Okay.
I'm sorry. I was asked that you go along with the recommendation. I believe he told me his max out date was also 2035 or something like that, Your Honor. So given that he's already serving time, and from my understanding that he might serve more than what his parole eligibility date is, Your Honor, I just ask that you go along with the recommendation. I'm not sure if the state mentioned it, but we are asking. The agreement was that it run concurrent with the current sentence.
Sure. I think that makes sense. Ms. Davis, did your office have any success reaching Mr. Garner?
No, Your Honor.
Okay.
Yeah.
Do we know, is he in custody somewhere now?
I'm not sure. I think that's probably very likely, but
Okay.
we're not able to make any contact.
Last question. Do we know how badly he was injured as a result of this?
One moment.
He didn't go to outside medical.
He did. Okay.
He didn't know he did it.
Oh, he did not. He stayed at Rice Street.
They took him to medical, and yeah, because when they brought me the warrant, they told me they ain't taking the outside medical or nothing.
Okay. Well, you know all the stuff, Mr. Nelson. Do you have any questions about anything we've been talking about?
No, sir.
Okay. Well, Mr. Nelson, I find there's a factual basis for your plea. You and Mr. Garner has some issue, and it sounds like you got the better of him. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to do this, and knowing means you've understood what we've been talking about. Do you agree with both those things?
Yes, sir.
All right. I'm going to sort of follow the recommendation, given that you're going to be in for a while longer and you've got a bunch of probation on the case for which you're already serving a sentence, I'm going to give you a straight time sentence. And so for each of the 4 counts in your indictment, I'm sentencing you to 2 years to serve. You will get credit from the day of your arrest, and there won't be any balance on probation because, one, I think you're going to be in GDC custody for what would be those 4 years of probation. But even if you get out early, you've got plenty of probation on your voluntary manslaughter case. And so we don't need to double up on that. So it's 2 years to serve, credit for the time you did serve. And I think that is it. Mr. Olaloye, do you authorize someone in my office to electronically sign the indictment for you?
I do, Your Honor.
Ms. Davis, can we sign for you?
Yes, Your Honor.
And Mr. Nelson, is it all right if we sign your name indicating your guilty plea in this case?
Yes, sir.
We'll do that. Do you have any questions about anything we discussed?
It ain't really about this case, but could you see my time that I took for all my other cases?
So, Your Honor, that was something I discussed with him yesterday. When I get the paperwork, I'll send it to you.
All right.
We discussed that yesterday.
Got it. So you have the other case numbers? I just have.
I do, Judge. It
You
just
do.
honestly wouldn't pull up the actual. Sometimes it runs slow. So I told him once I get it, I'll send it to him and duly.
Got it. Mr. Olaloye will get all that to you. My guess is your longest sentence would be the 20 to do 12.
Correct, Your Honor.
For the voluntary manslaughter, and the others are just running with it, sort of like this one. But Mr. Olaloye will get all that to you so you can have it and engage with folks down there, okay?
Okay.
All right, well, that's it. Thank you, GDC, for making him available. You're good to go.
Your Honor, that concludes my matters. May I be excused?
You may.
Thank you, Your Honor. Have a good day.
No, it would just be from that date. I got educated on that because of the thing yesterday with the other Georgia Justice people. All right. Can you get Mr. Hassan's lawyers out, please? Hey, I got about 5 minutes before I need to take that call. Do you need more time to speak with Mr. Hassan, or can we talk scheduling? Okay.
Also on July 17th,
Yep. So he's done in a week. Hold on one sec. Okay. What's the plan? Please, okay. Yeah, let's start with, Mr. Bass. We have a prosecutor in here, so you can go ahead and talk about the case.
Okay, can I bring Brenton out?
Why don't you tell me first what's going on?
I want to announce that there's a motion that was filed by previous council that I've adopted. We like heard, it's a bifurcation request of the, gun charges. Additionally, there's a request for a grand jury, inquiry in camera that you should have.
Yeah, I saw that. That's peculiar. I don't mean that in a bad way. I just never seen that request before. So we can talk about that. We can do that with Mr. Dennis. I'm gonna take a couple pleas. We do need Mr. Abate for anything substantive like what you just described. So you could? Great. You would grant all the motions? So the motion that you're adopting is to bifurcate, is it a felon in possession count?
Exactly.
Okay, all right. When we get Mr. Abate back in here, we need to deal with the Lemons case. Did Ms. Bumpus make it yet? Do we have enough? Can you reach out to her, please? Wonder what late means. Okay. So when he comes back, we can tackle some of that. But there were other announcements. Ms. Wood.
Yes, so Corey Rose, who is present, would like to proceed to trial and have been ready.
Okay, hold on. So that's position 30. Mr. Rose, where are you? Hey there. Okay, so you would like trial. You will need to come back on Monday. Make sure you're here Monday, 9 a.m. Your lawyer will be in touch with you, but you will be one of the cases that is in line to go to trial on Monday, okay? And you'll need to be available, I'm just looking at these charges, probably through Thursday of next week. So I don't know if you're working or you got other responsibilities, just know that.
I gotta go to work Monday, but I'm out Thursday, Friday.
So here's how that works. I call your case Monday morning. If you're not here, I issue a warrant for you. So you decide how you're gonna manage work or trial, but you've asked for a trial, you've got a right to a trial. I'll get you 12 jurors. They'll hear the evidence in the case. If they think the state has proved your guilt beyond a reasonable doubt, they'll find you guilty of aggravated assault and possession of a firearm. You're looking at up to 25 years. I'm not saying you get any jail time at all. If the jury says not guilty, then you're not guilty, but you don't get to skip your trial. You actually need to be here for your trial, and you're asking for one, and that starts on Monday. So I will see you Monday morning. I'm just letting you know that it could run through Thursday. Probably be done by Wednesday, but you would need to be here from 9 a.m. to 5 p.m. Monday, Tuesday, Wednesday at a minimum. If you're not, then we'll catch up with you eventually, and then you'll be waiting somewhere else for your trial. And it seems like you got a good gig, you got a job, et cetera. So you work with your employer, and please be here by 9 a.m. This courtroom on the 14th, okay?
All right, I can get that down in Ryan too. Like, it's a way for speaking.
What do you need?
I'll let you, I hear you, and your employer is gonna want some proof that you need to be here and that you're not at Dave and Buster's or something. I bet you Ms. Wood can get you a subpoena. It's a little peculiar to subpoena the defendant to the case, but she'll help you out, okay? And worst case scenario, I can put something on my letterhead. I don't know that you want a letter from me going to your employer, because I'll let them know what the deal is, but Ms. Wood will be your first stop, okay? Does this gesture mean okay?
All right, I was saying, it don't matter who do it, it don't matter if you do it or not. I mean, no, it just.
So I'm not doing it. How about that? If your lawyer will do something for you, great. I'm gonna see you at 9 a.m. on Monday morning, or I'll sign a warrant. Anything else?
That's it.
We're good?
I'm good, Judge.
All right. So Mr. Rose, have a good rest of your week. What time will I see you?
You'll see me Monday, Tuesday, Wednesday.
Yeah, what time? 9 a.m. Now, last thing, just so you're managing your expectations, if a different case goes out on Monday, I'll get you out of here by 9:30 and you don't need to come back. It's possible that a different case will go, but I don't know. And yours is on that short list. So you need to be here at 9. If we call your case out, then like you just said, Monday, Tuesday, Wednesday. But if we do a different case, you're good. You're off until probably the September trial calendar. Okay? Do you have other announcements, Ms. Wood?
Oh, yes, Judge. Robert Holiday, Station 16 and 16. Also that.
Okay,
And if we could just bring him to the door.
sure. I'll let him know when he needs to be here on Monday.
Yes, Judge. Holiday. Thank you.
Mr. Holliday, how are you? Good, you stay right there. You're good, right there. I just want to give you an update. You are on the short list for trial on Monday. So you will be brought back here Monday morning. Ms. Wood will have clothes for you to dress out in. I'm gonna let her coordinate with you if that's something coming from your family or if they have a clothes closet. You look fairly normal size, so they could find something for you. But if your family has clothes that you want to wear for court, they'll just need to get those to Ms. Wood. She'll get them here on Friday, so that when you come out for the jurors, you're dressed in street clothes rather than the handsome jumpsuit you're in. But you are on the short list for Monday for trial. Any questions about that?
Thanks.
You're welcome. You've been waiting.
Thank you.
Ms. Wood, other announcements? Not yet. Okay. Ms. Rios, what is the first plea you want to do? Mr. Stokes, come on up to the podium, please. That's position 17. Let me know when you're ready.
Thank you, Judge. I'm ready.
You're ready? Okay, great. Well, we're going to go on the record in State versus Stokes, 24 SC 004-596. Good morning, Mr. Stokes.
Good morning.
You are up here to take a plea in your case. Is that right?
Yes, sir.
Ms. Davis will put you under oath and ask you some questions. Please let me or Ms. Rios know if you've got any questions. All right? All right, Ms. Davis?
Please raise your right hand. I'm sorry.
So sorry to interrupt. Can I run that down as well since we're taking a plea right now, just to do a quick bond hearing?
Yes, I saw that Ms. Bumpus arrived as well. You've all been speaking. Good, okay. And we will have a conversation when you're back with Mr. Dennis out here about a couple motions that Mr. Bass has. Okay?
I know Ms. Davis will text me, so I'm not, bond hearing is delayed down there, I'll come straight back up here.
Sounds good.
Thank you.
Apparently you're going to be texting him.
I don't mind.
Okay. All right, sorry about that. Back to the Stokes plea.
Mr. Stokes, thank you for raising your right hand. Do you swear or affirm that the testimony that you will give before the court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can put your hand down. Please state your true, correct, and legal name for the record.
Terrell Jamon Stokes.
Okay. Are you at this time under the influence of any alcohol, drugs, or any medication?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 24 and last grade I attended was 11th grade,
And what high school did you attend?
Riverdale High School.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you're charged with the following offenses in indictment 24 SC 004596, aggravated assault with a deadly weapon, 3 counts, and possession of a firearm or knife during the commission of a felony?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer, Attorney Rios, about all the facts and circumstances known to you about this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Attorney Rios, do you waive formal reading of the indictment and any and all defects therein for the purposes of this plea?
Yes.
Mr. Stokes, do you remember having been arrested on these charges?
Yes.
Your Honor, the state's unaware of any outstanding warrants related to this charge and this case. Attorney Rios, are you aware of any outstanding warrants?
No.
Mr. Stokes, has your attorney advised you the minimum and maximum sentence for each charge to which you're pleading to today?
Yes, ma'am.
The aggravated assault counts are a maximum sentence of 20 years, and possession of a firearm during the commission of a felony is 5 years consecutive. Do you understand today that you're entering a negotiated plea of guilty, which means the state will recommend a sentence to the court?
Yes, ma'am.
Do you understand the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that you're pleading to multiple charges today, which can run consecutively or one after the other?
Yes, ma'am.
And Judge, I believe, and Ms. Rios, you can correct me if I'm wrong, is this a first offender?
Yes.
Okay, so I'm going to go through the first offender questions. Mr. Stokes, are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, ma'am.
Have you ever pled guilty to or nolo to any to or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, ma'am.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No, ma'am.
Has your lawyer explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked? You could be adjudicated guilty and you could be resentenced up to the maximum sentence for each charge on this indictment.
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including federal courts?
Yes, ma'am.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that is true regardless of any advice by your attorney or anyone else?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence from 1 to 15 years in prison?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, ma'am.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to possess or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a guilty plea?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury,
Yes.
the right to remain silent and not incriminate yourself,
Yes.
the right to confront witnesses against you,
Yes.
the right to have the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case,
Yes.
the right to the presumption of innocence,
Yes.
the right to testify on your own behalf and to present other evidence,
Yes, ma'am.
the right to subpoena witnesses and compel the production of evidence,
Yes.
the right to have the charges against you proved beyond a reasonable doubt,
Yes.
the right to appeal a convicted of these charges after a trial.
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today for the felony charges to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
How do you plead to the charges in indictment 24 SC 004596 to the charges of aggravated assault with a deadly weapon, possession, 3 counts, and possession of a firearm during the commission of a felony?
Guilty.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Can you repeat that for me?
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Your Honor, we believe that the facts at trial would show that on June 17, 2022, officers responded to 780 Aileen Drive in Northwest Atlanta to a shots fired call. There, they made contact with the victim, Mr. Andre Garrett, who was advised that he was shot by his daughter's boyfriend. The daughter was being evicted from her home, and it appears that while Mr. Stokes was pulling off, did discharge his weapon. It did strike the victim, Mr. Andre Garrett, in his leg/ankle. Mr. Garrett was treated. He did spend about a week away from work, but he is able to walk. He has full use of his leg, and we have been in contact with him in the past as of recent, not recently. However, he did say that he did not want to attend any hearings and that he was doing fine and he could walk when we did speak with him. That was bottom of last year.
Okay.
With that, and in consideration of the defendant not having a much of a criminal history at all, we are recommending the defendant serve 10 years total and for him to serve 20 weekends in custody, the balance probated, for him to receive anger management, no contact, to stay away from the victim, Mr. Andre Garrett, to do 40 hours community service. He has also been accepted into the Next Level Boys Academy, so that will be a requirement for him to fully participate and complete that program. I believe the way the math works, and Ms. Rios, you can correct me if I'm wrong, is it 15 years on the aggravated assault and 5 years consecutive on the firearm? I'm sorry, 5 years on the aggravated assault plus 5 years
5
on
plus
the firearm.
5.
Sorry.
Yeah, I
5
think
plus
that's how I
5.
broke it down in the email, right?
Yeah.
Okay. There are 2 other victims. There's Naisha Green and then Andre Garrett Jr. The indictment alleges that Mr. Stokes shot at them. He hit Mr. Garrett, and then I'm assuming Andre Garrett Jr. is his son. Is Naisha Green the girlfriend, or who is that, and what do we know about those situations?
I don't see any contact made with those 2 individuals. I believe they primarily just contacted and spoke with the dad. I don't know if that was a girlfriend or a mom, but that was his son that was also present.
Okay.
I don't believe that wasn't the girlfriend. The girlfriend was in the car with him.
I'm saying girlfriend of the dad.
Oh,
I'm sorry.
All right. Ms. Jackson, can you share with me Mr. Stokes's criminal history, please?
Yes, Your Honor. There are 5 cycles. The last arrest was October the 30th, 2022 in Clayton County for possession of marijuana less than an ounce and possession of a firearm during commission of a felony, and 2 counts of possession of Schedule 1 controlled substance. There was no disposition for that arrest, and there are no convictions listed in the GCIC, Your Honor. Nothing in addition.
All right, thank you. Ms. Rios, what's the status of the Clayton County case?
I don't think what happened with that case? I don't think he ever got called.
I just been waiting for them to send me a letter in the mail to come to court.
Okay, so that's just sitting out there.
Yeah.
All right. What can you tell me about Mr. Stokes and this shooting incident?
Yes, Your Honor.
I know you had filed an immunity motion and then you withdrew that.
Yes. I think the mother of his child initially was based on the victim or the dad pulled out a gun on him first, but then since they have broken up, she is no longer having that same statement or was going to say the same thing.
She doesn't remember it the same way anymore.
Yes.
Okay.
So that's why I withdraw the immunity motion. Mr. Stokes is 24 years old. He's currently working at Bad Daddy's restaurant. He's a chef there. He's been there for 4 months. Prior to that, he was a manager at Five Guys. He does not have any children, and he currently resides with his girlfriend. I'm not sure if you got it, but I sent Ms. Nelson lots of letters. So he has lots of support. I think it should be, have some letters.
I did. I have a letter from Dad and another relative. Anyway, it's a lot of letters.
I got a lot of letters and support. He also sent me, I'm not sure if I sent that to you, proof that he works. We have proof that he works at Bad Daddy's. And I have the acceptance letter from Next Level Boys Academy.
So I had a question about that. What's their age limit?
25. So he just made the cutoff. We had me and Mr. Davis had a long discussion. So yeah, as long as they're before they're 25, they can go in.
Okay.
And so based on him not having much of a criminal history and like no violent arrest at all, this incident happened about 3 years ago, and he hasn't had any violent charges before that or since. I believe this was an isolated incident, and I believe with the Next Level Boys Academy, we will ensure that something like this doesn't happen again with that support that he'll be getting from them. So I ask that you accept the plea as negotiated and set a behavioral incentive date of 4 years.
So, Mr. Stokes, the girlfriend you had at the time is not the girlfriend you have now?
No, sir.
Okay. And she was getting evicted by her dad?
She was put out.
By her dad?
Yeah.
Got it. So she and her dad were having some disagreement?
Yes.
Okay. And you got involved?
I was just only going to pick her up, her and her things, and to go. And
okay.
Yeah.
Who is the Ms. Green that's in the indictment? Is that your former girlfriend, Naisha Green? Does that name ring a bell?
If I'm not mistaken, I think that's her dad's girlfriend.
Okay. So at this house where your former girlfriend, what was her name?
Nashada.
What was her last name?
Garrett.
Garrett. So Ms. Garrett is getting put out by her dad from her house. Ms. Green would be dad's girlfriend.
Mm-hmm.
And then Andre Garrett Jr. would be, I guess, her little brother.
Yes.
And was he a little kid, a big kid?
He was 18 at the time.
Okay, so he's an adult-ish also. And so what was happening? Why are you doing anything other than you're waiting in the car and your girlfriend gets in the car?
Her things was on the ground, so I got out the car to help her pick up her stuff, and her dad didn't like the fact that I was there at his house. And
were you not popular in the household?
No, I had only met the dad like twice before that. So
how long had you been talking to this woman?
Probably like 2.5 years.
Oh, and you only met dad twice?
Yes.
Oh, okay.
So yeah, so I could just get out the car to help her pick up her things.
Okay, and he didn't like that?
He didn't like that at all.
Did his son, your then girlfriend's brother, did he play any role in it, or he's just sort of watching what's going on?
He came from behind the house with some type of play rifle, play gun or something. I don't know what it was, but it looked like a gun.
Okay. And was engaging with you, or he also was unhappy you were there?
I mean, he wasn't saying anything, but
okay.
It was tension. You could tell.
Got it. And then how about the dad's girlfriend, Miss Green? What was she doing?
Just standing there.
Okay. Yeah. And what was the issue between your then girlfriend and her dad? Why was he kicking her out?
So I learned that she was being disrespectful to him, and he punched her in the lip and put her out. Okay.
Got it. And had she called you to say, hey, come get me?
Yeah, she sent me a text. It was like, can you come pick up me and the kids that she have and her stuff?
So she had kids?
Yeah.
Two kids. All right. And were they out there when this all happened too? How many times did you shoot?
It was 4.
All at just Mr. Garrett Senior?
Yes.
Okay. Did he ever shoot?
No.
Did he have a gun?
Yes.
Not the big gun that his son had?
No.
Okay.
It was a handgun.
Okay. And what did you have?
I had a handgun as well.
All right. Did you stay there afterwards, or did you hop in your car and drive away?
I hopped in my car and drove away because I was nervous. I ain't know if it was going to continue to escalate. So.
Did your then girlfriend hop in the car with you, or did she stay with her dad?
She hopped in the car with me.
With her kids too?
Yes.
You guys got out of there?
Yes.
How did you first get involved with the police? Did you turn yourself in and say, look, there was this incident and I was defending myself, or did they come find you and drag you out of your house?
So I had got a call from the detective to tell me to turn myself in. So I had turned myself in I didn't turn myself in. I actually got locked up in Clayton County prior to turning myself in. So.
For this drug case?
Yes.
How long had you been not turning yourself in?
I think the detective contacted me in like October, early October. So I was probably on the one for like a month.
Okay.
Yes.
But instead of turning yourself in, you just coincidentally got scooped up in Clayton County.
Yes.
Okay. Anything else?
No, sir.
All right. And what you're saying, Ms. Rios, is that the former girlfriend, when she initially spoke with you, corroborated Mr. Stokes?
I never spoke with her the first,
Oh.
when he heard his version, and then I was having a hard time getting in touch with her, and finally my investigator got in touch with her, and she was saying a whole bunch of different stuff. I guess one of the things was, he's letting me live back there. I'm not trying to basically piss him off.
Meaning I'm back home with my dad.
Trying to go back home with my dad.
Now is not the time to ruffle those feathers.
Yeah.
Okay. All right. Anything else, Mr. Stokes?
No, sir.
This job you have, what are the hours?
So I do night shift, so I do 40-11, but I started doing double shift, so I do like 9 to 9.
Lots of hours. And what days of the week?
It's not set days, so they kind of mix up my schedule.
If you are not available Saturdays and Sundays for a long time, is that going to affect the job, or they'll just know that they can't put you on a Saturday or a Sunday?
No, it's not going to affect my job.
Would you prefer that your weekends are different days of the week? Because there's nothing magic about Saturday, Sunday.
Yeah.
If it's better for you to be off Tuesday, Wednesday, because that's quieter times at the restaurant, it can be Tuesday, Wednesday. I don't really care.
Okay.
Do you have a preference?
No, sir.
Okay. You don't think?
Because I had already, when I heard that about the weekend jail, I had already updated my availability.
You blocked out all those weekends?
Yeah.
Okay.
So Friday, Saturday, and Sunday, I can't work.
Okay. All right. Well, Mr. Stokes, I find there's a factual basis for your plea, and that your plea is knowing and voluntary, meaning you've understood everything we talked about. No questions about anything?
No, sir.
Okay. I'm sentencing you pursuant to the Probation Options Management Act, which just means that while you're on probation, which you will be for a while, if you have a real small violation, you and probation will figure out what to do with that. But if you get arrested for anything, you skip any of these weekends, something like that, you get kicked out of Next Level Boys Academy, that comes back to me for adjudication. Ms. Rios, can someone in my office sign the indictment for you?
Yes, Your Honor.
Ms. Davis?
Yes, Your Honor.
And Mr. Stokes, can we sign it for you?
Yes, sir.
Do you have a weapons carry license?
No, sir.
First offender is something you qualify for, and it is mostly a good opportunity because it means that you won't have a felony on your record, which helps with work, if you're going to go back to school, et cetera. Those are all good things about first offender. The risk you have is that if you mess up while you're on first offender probation, and the worst thing you could do would be get caught with a gun again, because no guns while you are a first offender probationer, even though you're not a convicted felon. But if you get arrested, you've got a gun on you, that'll come back to me. And not only could I revoke your first offender status, but I could resentence you. So the sentence that your lawyer is recommending is primarily probation. But whatever I end up imposing, I could look back at this and say, you have not gotten over your gun thing because you got arrested with a gun again, and say, you know what, I'm going to give you 10 years to serve on these shootings and then another 5 for the other count without a trial, because you've already said I did these things. So there's a downside to first offender as well. Do you feel like you understand the risks and benefits of first offender?
Yes, sir.
And do you want to be sentenced as a first offender?
Yes.
All right. Are you wearing an ankle monitor still? That'll come off as soon as Ms. Rios can get you a copy of your sentence. You can go to second chance with that and they'll remove it. And I encourage you to do that, because otherwise you're still walking around with that thing.
Yeah.
And have you had one since you got out?
Yes.
Okay. County funded?
Yes.
Okay. Yeah, so get that final disposition, that's what it's called, from Ms. Rios, and go to second chance and they'll take it off. All right, well, Mr. Stokes, this is a complicated one. Things could have turned out so differently. You pull a trigger, you don't control where the bullet goes. It could have hit I guess he's not a kid, he's a big guy with what looked like an assault rifle, but any one of these people could have been shot. Could have been more than just an ankle. It sounds like your view of it was that you were acting in defense of what was coming at you. We're not going to litigate that, but you can't be carrying guns anymore. And so if you get in a situation like that and you feel like you need to protect yourself, it's a baseball bat or your hands, or better yet, you hop in the car and drive away. Hopefully you don't get in a situation like that. Your current girlfriend has better relationship with her father?
Yes.
Okay. Have you met her father before?
No, not yet.
Oh, all right. Well, okay, we'll see. Hopefully he doesn't get a call from Mr. Garrett first. So what I'm going to do in terms of sentencing is for counts 1 through 3, I'm going to sentence you to 5 years to serve 3 months with the balance probated. Count 4 has to be 5 years and has to be consecutive. So I'll run that consecutive to count 1, but 1 through 3 are concurrent with each other. So it's a total sentence of 10 years to serve 3 months with the balance on probation. You'll get credit for the time you already did. Special condition of probation number 1 is no contact with Mr. Garrett Sr. or his family.
Yes, sir.
Don't call them, don't write them. If you know someone who knows them, don't go through that someone else to say, I'm sorry for what happened, or I'm gonna come get you. Any contact from you, direct or indirect, is gonna get you into some trouble. Special condition number 2 is that you will complete 20 weekends in the county jail. You need to report to the county jail by 5 p.m. on Friday. Do you want to start tomorrow, or is that too soon? We can start the following Friday if that's better.
Yeah, because I gotta work this weekend.
Okay.
Yeah.
Then this wouldn't be the right weekend to start. So on July 18th, that's next Friday, by 5 p.m., you got to show up at the county jail.
Okay.
They'll book you in, and by 5 p.m. on Sunday, they book you out.
Okay.
So, and you're gonna do that 20 weekends in a row. That's a long time, but this is a serious situation. And I think it is justified. If for some reason there is an emergency in your life and you know you can't make a weekend, mom is sick, kid, you don't have kids, something, and you've got to deal with that, you need to reach out to probation and say, I'm going to the hospital. And then you're going to need to get paperwork showing that you, in fact, were at the hospital. Not necessarily for you, but for your loved one. Because if you miss a weekend, I learned about that from probation, and I'm going to turn every weekend you miss into at least a month in jail. So don't miss weekends.
Gotcha.
All right? So you'll have 20 of those. You'll need to complete an anger management course, and I'm going to require that be done within the first 6 months of your probation. You'll need to do 40 hours of community service, and you'll need to participate in and complete the Next Level Boys Academy. I hope they don't meet a lot on the weekends because you're not going to be able to do much with that for the first 20 weekends.
No, I think we meet once on Saturday, and we have Zoom call on Monday and Wednesday.
Okay. Well, the Saturdays are going to be tricky for you because you'll be doing something else.
Mr. Davis knows about it and said he'll work with him.
Okay, good. Mr. Davis is flexible in that way. I'm adding one condition of probation is that's that you get your GED. And I'm going to require you to be enrolled in the GED course within the first 3 months. That just means you get it started so that you close that loop and get that high school degree through a GED. And I will set a behavioral incentive date of July 11th of 2029. So that's 4 years from now. What that means is if you've done everything that is expected of you in this sentence and there have been no new issues, then probation can ask to have your case shut down. By then you'll be 28. And if you have stayed out of trouble, you're on a great trajectory. And there's no reason to have someone looking over your shoulder anymore. Couple things to keep in mind. You've got this Clayton situation. And if they're not reaching out to you, they're not reaching out to you. That's an old case now. They may have decided they're not doing anything with it. But if it comes up, you got to go deal with it.
Yes.
And you'll want to let probation know that you're going to deal with that down in Clayton County. You've used up your first offender, so you won't be able to make that a first offender. Because it's a drug case, there may be something a lawyer can do for you that's similar, but you're done with first offender through this case. And then I just want to remind you of the fragility of a first offender sentence. If you're back in front of me because you've been arrested for something involving guns or violence or anything like that, your first offender sentence is going to blow up on you. Okay? And I don't say that to threaten you at all. You seem buttoned up now. You're working hard, and you seem to understand the direction you need to go. I'll tell you, I'm not getting the Clayton County arrest because that doesn't seem like your deal. But we don't need to talk about that situation, but that doesn't seem to fit where you are in your life now. So I hope that doesn't come back to grab you in some way, and that you're able to move forward. I think I covered everything. Ms. Davis, anything else in Mr. Stokes's case?
No, Your Honor.
Ms. Rios?
Your Honor, thank you.
Mr. Stokes, what county do you live in?
DeKalb.
DeKalb County. All right. Ms. Simpson, who's seated right there, is going to give you reporting instructions for probation.
Okay.
Probation in DeKalb is based in Conyers. So you got to go way out there. Your first time where you say, hey, I'm Mr. Stokes. Your first reporting will be to the office in Conyers.
Okay.
After that, you and your officer will figure out how you stay in touch. Just make sure you make yourself available. If they have to work hard to find you, sometimes they just say, I'm going to get a warrant for the guy because I can't track Mr. Stokes down. So don't be scarce.
Okay.
All right?
Yes, sir.
Ms. Simpson?
So, Mr. Stokes, your reporting date will be July the 17th.
Okay.
AM. And I'll give you a report instructions with the address and the contact info for that office.
Okay.
All right. So don't miss that reporting date. 8 a.m. July 17th. That's a week from today. Way out in Conyers. Where do you live in DeKalb?
Clarkston.
Okay.
It's not too far from Conyers.
Perfect. You're going. Well, if that's it, Mr. Stokes, I hope things go smoothly for you.
Thank you.
All right. What's next?
Marius Favors.
Mr. Favors, come on up, please. Stokes. number 19.
Mom here.
Yeah, man.
This is the situation with the non-complex case that we're putting on hold.
Yes, Your Honor. Correct.
Okay, and we'll get all that on the record?
Yes, Judge.
Okay, all right. Speaking of records, let's get on it. This is position 19, 24 SC 0054447, State versus Favors. Mr. Favors is here in court with Ms. Rios. We have Ms. Davis for the state. Mr. Favors, it sounds like you're ready to enter a plea in your case?
Yes, sir.
Okay. We've sat through one now. You know how it's going to flow. Ms. Davis is going to ask you some questions. You'll need to answer those. And let me know if you've got any questions or if there's anything you don't understand, okay?
Okay.
All right, let's do it.
Mr. Favors, please raise your right hand. Do you swear or affirm the testimony that you will give in the matter before the court shall be the truth, the whole truth, and nothing but the truth?
Yeah, ma'am.
Okay, you can put your hand down. Please state your true, correct, and legal name for the record.
Jamari Faye.
I need you just to speak up a little bit. Can you spell your first name for the record?
JAMARIUS.
Are you at this time under the influence of any alcohol, drugs, or medication?
No.
Is there a medication that you normally take that you have not taken today?
No.
How old are you and how far have you gone in school?
19 in the 11th grade.
What high school did you attend?
Virgil Douglas High School.
Are you able to read, write, and understand the English language?
Yes.
Are you a United States citizen?
Yes.
Do you understand that you're charged with the following offenses? An indictment 24 SC 005447, theft by taking, possession of tools for the commission of a crime, and willful obstruction of a law enforcement officer. Judge, we are moving to null pros the fleeing and attempting to elude a police officer. There was a third co-defendant that was a minor. He was basically turned into his parents, but he was the driver.
Oh.
I know that the statute allows it, but considering the fact that he was the driver, I didn't think it would be appropriate.
Yep.
Okay.
Okay.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your lawyer, Attorney Rios, about all the facts and circumstances known to you in this indictment and any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes.
Attorney Rios, do you waive formal reading of the indictment and any and all defects therein for the purposes of this plea?
Yes.
Mr. Favors, do you remember having been arrested on these charges?
Yes.
Your Honor, the state is unaware of any outstanding warrants related to this matter. Attorney Rios, are you aware of any outstanding warrants related to this?
No.
Mr. Favors, has your attorney advised you the minimum and maximum sentence for each charge to which you are pleading today?
Yes.
For theft by taking, the maximum sentence based on the amount is 10 years. For the possession of tools for the commission of a crime, the maximum sentence is 5 years, and willful obstruction is 12 months. Do you understand that today you're entering a negotiated plea of guilty, which means the state will recommend a sentence to the court?
Yes.
Do you understand the court is not required to accept the state's recommended sentence?
Yes.
Do you understand the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand that there are multiple charges to which you are pleading to today, and the court has a right to run those sentences consecutively or one after the other?
Yes.
Is this also a first offender, Ms. Rios?
Yes.
Mr. Favors, are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pleaded guilty or nolo or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for a crime, felony or misdemeanor under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including federal courts?
Yes.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? And that is true regardless of any advice by your attorney or anyone else.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'll be guilty of a felony, which may carry a sentence from 1 to 15 years in prison?
Yes.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury,
Yes.
the right to remain silent and not incriminate yourself,
Yes.
the right to confront witnesses against you,
Yes.
the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney in a trial of your case,
Yes.
the right to the presumption of innocence,
Yes.
the right to testify on your own behalf and to present other evidence,
Yes.
the right to subpoena witnesses and compel the production of evidence,
Yes.
the right to have the charges against you proved beyond a reasonable doubt,
Yes.
the right to appeal if convicted of these charges after a trial.
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today for the felony charge and 12 months from today for the misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
How do you plead the charges? How do you plead to the charges in indictment 24 SC 005447 to theft by taking, possession of tools for the commission of a crime, and willful obstruction of a law enforcement officer?
Say it again.
How do you plead to the charges of theft by taking, possession of tools for the commission of a crime, and willful obstruction of a law enforcement officer?
Guilty.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Your Honor, we believe that if this case were to go to trial, the record would show that on June 10th, 2024, about 5:30 in the morning, officers observed a 2016 Hyundai Elantra driving in the roadway without headlights. The officer, Officer Meha, initiated his emergency equipment, attempted to initiate a traffic stop. That traffic stop was disregarded. The vehicle was driven to Allen Temple Apartments. However, the incident occurred at 345 7th Street, Northeast Atlanta, Georgia, in Fulton County. The suspects exited the vehicle and fled on foot. Officer Mayhew was able to detain one of the males in the vehicle. He did radio for other support, and they were able to detain the other two individuals who were in the vehicle. Officer Mayhew performed a show up and positively identified all the suspects in the vehicle. When they did observe the vehicle, they noticed the steering wheel column had been tampered with, window glass had been shattered, so there was forced entry. They located two window punchers, a glove and a ski mask. This vehicle belonged to Miss Emily Chansey. She had parked the vehicle the day before, and when she went out on June 10th to 7 o'clock in the morning to go to her vehicle, she discovered that it had been stolen. So the state is recommending a probated sentence. I believe the defendant has two cycles, both similar kind of set of facts in 2024. That second case is 24 SC 005327. We are offering the defendant 3 years probation. He'll be required to do an anti-theft course, 50 hours community service, obtain his GED, or remain employed. He is to have no contact with his co-defendants in both cases, Mr. Darshawn Taylor and Mr. Trayvon Willis. If Mr. Favors can successfully complete the terms and conditions of the probation, then the state would be moving to null pros the second case. This was a candidate that we thought would be eligible for diversion, but because of the second case at the same time, he was not able to be accepted.
Okay. Any restitution for Ms. Chansey?
I believe I did try to reach out to Ms. Chansey. I'm not sure there is any restitution, Judge, but I will confirm.
Okay, well, we'll leave it out for now. If that changes, you can let me know.
Thank you, Judge.
Ms. Jackson, any criminal history information on Mr. Favors?
There are 2 cycles. The last arrest was February the 20th, 2023, with the City of Atlanta Police Department for theft by receiving stolen property and possession of tools for commission of a crime. There was no disposition for that arrest, Your Honor, and there are no convictions. Nothing in addition.
Thank you. Ms. Rios?
Yes, Your Honor. Mr. Favors is 19 years old. He lives here with his mom, I believe she's here, and he has 4 siblings. He was previously working at a warehouse, but right now he's unemployed. I did reach out to the At Promise program. He did have a meeting with them, and I think at 4 p.m. today, he's supposed to meet with them again. And so he's going to go through them to get his GED. They also offer case management services and forgot the list of things, other like help with work. And they have another program, but he has to get his GED before that. And then he can go to the other program that is also like life building skills. And so I think that would be a good thing for him. It seems like he's still very, very young and he's on the verge of things can turn around. And I think with this program, I didn't even know about this program until Ms. Davis told me to look into it. And so it seems to have a lot of stuff and they even give like a stipend, I believe. So hopefully with that, he'll be on the right track.
Okay, sounds good. Mr. Favors, anything you want to add about this situation?
No.
No. Okay. I missed one part because I was reading in your case file. I know you're 19 and Ms. Davis asked you how far you went in school. How far did you go in school?
11th grade.
Okay, and where was that?
Virgin Davis High School.
All right. Okay. And you stay right now with your mom?
Yeah.
And then you have brothers and sisters who stay there too?
Yes.
How many?
4.
Are they older or younger?
Younger.
You're the oldest?
Yes.
Okay. And mom is here where? Right there. Hi, mom. I'm all right. Thank you for being here. All right, Mr. Favors, you don't have to keep standing. I just wanted to know which one was mom. I find there's a factual basis for your plea, and that your plea is knowing, meaning you've understood what we talked about, and voluntary. No one's forced you to enter this plea. Do you agree with that?
Yes.
Okay. You don't have questions about anything?
No.
So I'm going to sentence you pursuant to the Probation Options Management Act. And all that means, Mr. Favors, is that while you're on probation, I hope you have no problems, but if you have a little problem, maybe you miss a meeting or something, you and probation will figure out what to do about that. But if it's a bigger problem, you get arrested again, you're driving in a stolen car, that comes back to me and we'll work through that. Ms. Rios, can someone in my office sign the indictment for you?
Yes, Your Honor.
Ms. Davis?
Yes, Your Honor.
And Mr. Favors, can we sign it for you, indicating your plea?
Yes.
All right. Tell me what you think first offender is.
To be honest, I don't even really know.
Okay, I'm going to tell you a little bit about it because I think you're asking to be sentenced as a first offender. So you just pled guilty to some felonies. So you would be, if I don't sentence you as a first offender, you'd be a convicted felon. Means you can never have a gun, means you cannot vote. It's going to be harder to get a job because a lot of job applications, one of the first questions after what's your name is, are you a convicted felon? And you would be if I don't sentence you as a first offender. A first offender, which you qualify for because you haven't been convicted before, is sort of a second chance. We really could call it second chance, but we call it first offender. If you do well on your sentence and you finish your sentence with no big problems, then we erase this. It's like it never happened. And that helps if you're trying to work or go back to school or whatever. That's the good part of first offender. But there's a risk if you aren't so sure that you're done running around with folks like Darshawn Taylor and your co-defendant in the other case, stealing cars, and you get arrested again, then first offender actually gets real messy for you because we would not have a trial, we'd have a hearing, but the state would just have to convince me a little bit that you got in trouble again, and then I could resentence you in your case. And I've got 10, 15, 16 years to work with So right now, you'd be getting a sentence that's just probation. But if we're back here in 6 months, a year, and Mr. Favors has gotten arrested again, I might revoke 4 or 5 years and it becomes a conviction. So it gets kind of messy real quickly, this first offender thing. If you're pretty sure you're not going to get in trouble anymore, first offender is a good idea. But if you aren't so sure which way you're heading, then first offender is a pretty risky thing to do. Does that help you better understand what it is?
Yes,
Do you want to talk about it with your lawyer, or do you feel like you understand it?
I understand.
Do you want to be sentenced as a first offender?
Yes.
Okay, well, we'll do that. So, Mr. Favors, what I'm going to do on count 1 is sentence you to 3 years, count 2, 3 years, and count 4 is 3 years. Count 3 has been dismissed. I'm sorry, count 4 is 12 months. They're all running at the same time. So it's a 3-year sentence. It's probated, so it's all on probation. Special condition of probation number 1 is that you get to the At Promise Center and enroll in their GED program. You need to do that within the first month of your probation. Okay?
All right.
And then I'm going to encourage you to do other programming at the At Promise Center, but I haven't figured out how to get that into a sentence yet. I have to talk with the At Promise folks. But I know the GED piece you're going to do. Number 2, you are going to complete 100 hours of community service, but you've got your whole sentence to do that. You just need to make sure you've done the first 30 hours of community service in the first 3 months of your probation. No contact with your co-defendants in your 2 cases. And you're going to take an anti-theft course. So GED at Promise Center, community service, anti-theft course, no contact with Mr. Taylor or the defendant in your other case. And I will put on judicial hold 24 SC 005327. That's your other case. Okay? Do you have any questions about anything we talked about?
No.
Tell me what county you live in.
Fulton County.
All right. Ms. Simpson is going to give you some probation reporting instructions. She's going to, in the end, hand you a piece of paper that has the date and time that you have to show up at the probation office. Do not miss that appointment, because if you do, they're just going to send me a warrant if you're not there. Okay?
Yes, sir.
All right. Any questions about anything?
No.
What are you doing this weekend?
Man.
Nothing? You're going to just sit in a chair and stare at the wall all weekend?
Oh, no. Nah.
So what are you going to do this weekend?
I don't know.
You're going to hang out with friends, take care. How young is your youngest brother or sister?
Like 10, I think.
They live with you?
Yes.
All right, so 10?
Yes.
Do you ever watch them, or is that a bad idea for you to be in charge?
No, I don't watch them.
You don't watch them?
No.
Okay. So what are you going to do this weekend?
I'm be in the house.
Why are you going to stay in the house all weekend?
Cause I don't know. I don't go outside like that.
All right. Well, that's what you're going to do for the weekend. Ms. Davis, anything else in Mr. Favors' case?
No, Your Honor.
Ms. Rios?
Just one thing, since there was a bench warrant attached to the other case, will you take care of that and take that out? And I don't know how that works.
If you'll reach out to Ms. Nelson about that, yes,
Okay.
because here's Mr. Favors and he's going to be on probation, so we're going to know how to find him.
Okay.
Sure.
Thank you.
Happy to do that. Ms. Simpson?
30318.
So your reporting date is July the 15th at 8 a.m. And you're going to report to the Atlanta office, which is at 276 Memorial Drive. And it's about 5 minutes from here.
All right.
And I will get your registration so you can post.
Okay.
All right. Good luck. Can you see if Mr. Abate is ready, please? That was a long bond hearing in front of Judge Schwal.
I do think Mr. Rios And we have one more plea too as well. We have one more.
Who do we have here?
Wait, Mr. Fields. Kendall Fields.
All right. Number 31. What are you doing this weekend?
Working.
Working. Okay. Not sitting in a chair staring at the wall. Are you ready, Miss Davis?
Yes, Judge, I'm ready.
Okay. Well, let's do this one while we're waiting on Mr. Bate.
Text.
You did text him?
I did.
Excellent. Thank you. Ms. Rivers, you good?
Yes.
All right. This is position 31, 25 SC 000199, State versus Kendall Fields. Mr. Fields is here in court with Ms. Rios. Ms. Davis is here for the state. And Mr. Fields, you've now sat through a few pleas, so I think you understand what the flow is going to be like. But Ms. Rios says you're ready to enter a plea. Is that right?
Yes.
Okay. When you're ready, Ms. Davis.
Mr. Fields, thank you. You've raised your right hand. Do you swear or affirm the testimony that you will provide in the matter before the court will be the whole truth and nothing but the truth?
Yes.
Okay, you can put your hand down. Please state your true, correct, and legal name for the record.
Kendall LaShawn Fields.
Can you spell your first name for the record?
Kendall.
Are you at this time under the influence of any alcohol, drugs, or medication?
No.
Is there any medication that you normally take that you have not taken today?
No.
How old are you and how far have you gone in school?
25, 3 years of college with a plan to complete.
And where did you attend college?
Morehouse College.
You going back to Morehouse or somewhere else?
That's the plan. I'm too far in.
I mean, it doesn't have to be Morehouse though. I mean, you got the credits you got, but you,
If my credits are set up, it might have to be.
okay. But that's your plan, is to go back there anyway. When did you stop?
My last COVID made things foggy. My last enrollment year, I think, was 2022, 2023.
Okay. And you, based on credits, you think just 1 year left?
Yes, sir. No, I know for a fact.
Okay.
Are you able to read, write, and understand the English language?
Yes.
Are you a United States citizen?
Yes.
Do you understand that you're charged with the following offenses in indictment 25 SC 000199? Purchase, possession, or having in your control Schedule 1 substance or Schedule 2 substance, possession of a firearm during the commission of a felony, fleeing, and affixing materials to the window. Judge, after reviewing the evidence and the video footage of the fleeing, while Mr. Fields was slow to stop, he was not speeding. He did not cause an accident. It meets within the bounds of the misdemeanor fleeing
Okay.
statute. And the state is also going to move to null pros the window tint shield violation.
So null processing the window tint, and then is the count charged as felony fleeing and you're reducing it?
I am reducing it
Okay.
to a misdemeanor.
All right. Is that the same code section? Is
It
it a
is.
different letter?
Well, actually, it may be the misdemeanor because I want to say the misdemeanor is section A and the felony is B, if I'm not mistaken.
Ms. Rios, you can correct me if I'm. Last attorney said it was a felony, so I was like. Yes, that's correct. Subsection A is a high and aggravated misdemeanor.
Okay,
Okay.
got it. So it's charged that way.
Yes.
All right.
Mr. Fields, do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yeah.
Have you had enough time to speak with your lawyer, Attorney Rios, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes.
Attorney Rios, do you waive formal reading of this indictment and any or all defects therein for the purposes of this plea? Yes. Mr. Fields, do you remember having been arrested on these charges?
Yes.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Attorney Rios, are you aware of any outstanding warrants related to this matter? No. Mr. Fields, has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading to today?
Yes.
For the possession of a controlled substance, the maximum sentence, I believe based on the amount, is 8 years. The possession of a firearm during the commission of a felony is 5 years consecutive. The fleeing is a misdemeanor, which would be 12 months. Do you understand that today you're entering a negotiated plea?
So there's one more count. There are 5 counts in the indictment. I know you dismissed count 5, which I think is window tint.
Correct.
But count 2 is that the handgun serial number had been removed.
I'm not no processing that.
Okay.
The maximum sentence for that charge is 5 years.
Okay.
I'm going to ask my question again. I'm sorry, Mr. Fields. Do you understand that today you're entering a negotiated plea of guilty, which means the state will recommend a sentence to the court?
Yes.
Do you understand the court is not required to accept the state's recommended sentence? That's a plea. It's still a plea. It's still a mistake.
Repeat your question, please.
Do you understand the court is not required to accept the state's recommended sentence?
Understood.
Do you understand the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand that there are multiple charges to which you are pleading guilty today, and the court has the right to run those sentences consecutively or one after the other?
Yes.
So I just want to correct one thing. It's not going to change where we're heading today. I've had many cases with the no serial number on gun, but it's actually 1 to 10 for a firearm. For any other, for a vacuum cleaner or a radio or a piano, it's 1 to 5. But for a gun, it's 1 to 10. So stick with the pianos with no serial numbers.
My apologies, Judge. Reckless driving. We're gonna do reckless driving instead, so that won't make your license suspended. Finish going through my thing. Just let me know when if you're, I'm sorry, we had a side.
Oh, I'm good. No, I was waiting on you. I know Ms. Rios was doing some shuttle diplomacy.
Yes.
So I'm just reading the arrest warrant.
Okay, and I would like to clarify at the end, the
Okay.
charges, if that's okay, just to
Okay.
make sure nothing else is missed.
Okay.
There's some concern about a driver's license, right? Okay.
Okay.
Do you understand that there are multiple charges to which you are pleading guilty today, and the court has the right to run those sentences consecutively or one after the other, Mr. Fields?
Yes.
Do you understand that this plea may be used to enhance sentencing and other convictions in this jurisdiction, as well as other jurisdictions, including federal courts?
Yes.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? That is true regardless of any advice by your attorney or anyone else.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'll be guilty of a felony, which may carry a sentence from 1 to 15 years in prison?
Yes.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury,
Yes.
the right to remain silent and not incriminate yourself,
Yes.
the right to confront witnesses against you,
Yes.
the right to the assistance of counsel hired by you or court-appointed counsel if you cannot afford an attorney at a trial of your case,
Yes.
the right to the presumption of innocence,
Yes.
the right to testify on your own behalf and to present other evidence,
Yes.
the right to subpoena witnesses and compel the production of evidence,
Yes.
the right to have the charges against you proved beyond a reasonable doubt,
Yes.
the right to appeal if convicted of these charges after a trial.
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
How do you plead to the charges in indictment 25 SC 00199? And just hold off for a second. So Judge, we're moving forward with the possession of a controlled substance, the altered mark on the weapon, and I am amending the fleeing charge to a reckless driving.
Okay.
And I have no objection to the defendant pleading nolo, so that his license may not be impacted and may not receive any points for the reckless driving offense. I am null processing the affixing tint to the window shields.
And you're also going forward with the possession of a firearm during commission of a felony?
Correct. Thank you,
Okay.
Judge. Still this one.
So the fleeing is now reckless driving,
Yes, Judge.
which is a misdemeanor.
Yes.
Okay. And that's not going to help his driver's license, but you're saying that won't cause him to forfeit the driver's license?
Correct. If the judge or if the court allows a nolo on that charge, if he has not done it in the last 5 years, then he should not receive any points. And that is what you would get for a reckless driving. You get points,
Okay.
which could cause your license to be suspended depending on how many other traffic offenses he has.
Okay. But the nolo is only to the reckless driving, not to all the other stuff?
Correct.
Okay.
Yes, only limited to the Title 40 offense.
Okay.
How do you plead?
Guilty.
To all the charges?
Except the guilty on everything except the reckless. That's no.
Yes, guilty except for the reckless.
That's NOLO. Safe.
Oh, that's NOLO.
Has
So
anyone?
we're clear for the record, that's count 4. So it's guilty to counts 1, 2, and 3, which is drugs, altered serial number, and firearm. That's guilty. Count 4 is nolo to the reduced charge of reckless conduct. Count 5, the state is dismissed. You agree with that?
Yes.
Okay.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No.
Is it your decision to waive these rights and enter this plea because you are in fact guilty?
Yes.
Is this plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Your Honor, the state believes at trial, we would show that on
First offender colloquy, we might be able to do it because he did conditional discharge.
okay.
I have the disposition and it says conditional discharge from the other case.
Okay. Judge, I believe Ms. Rios, if we can make sure we hear it for the record, you're requesting first offender treatment.
Yes, Your Honor.
Okay.
So Mr. Fields, I'm not done. I still have some more questions for you, okay?
Uh-huh.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pleaded guilty or nolo or ever been convicted of a felony in the state of Georgia or any jurisdiction?
No.
Have you ever been sentenced for any crime for felony or misdemeanor under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Yes.
You understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked. You could be adjudicated guilty and you could be resentenced up to the maximum sentence for each charge in this indictment.
Yes.
Your Honor, the state believes if this case were to go to trial, the record would show that on March 18, 2023, Officer Gonzalez with the Georgia State Patrol observed a white Kia Optima traveling westbound on Virginia Avenue with dark window tint. At that time, the officer activated his emergency equipment, attempted to initiate a traffic stop. It did take Mr. Fields about a minute or so to pull over. It looked like he made a turn into the interstate and then finally brought it to a rest on, I guess, just past the ramp of the interstate, but he was traveling at a regular speed. Upon making contact with the defendant, the officer noticed the distinct smell of marijuana coming from inside the vehicle. He initiated a search after he detained the defendant based on that suspicion, that articulable suspicion of marijuana. He did locate some marijuana as well. He also located 4 pills, and the drugs were tested, which came back as less than 3 grams of methamphetamine. He also recovered from the vehicle a firearm, and that firearm had some of the serial numbers, I guess, filed off. And so that is why he was charged with that count of the indictment.
All right.
We are asking for a sentence of 6 years probation, a drug and alcohol evaluation, treatment if treatment is required, 40 hours community service. And because Mr. Fields has a high school diploma or GED, we're asked that he remain employed during the duration of this probation.
All right, let me check one thing. Okay. So 6 years probation, evaluation and treatment, and 40 hours community service. And then working if he's not, I mean, if he's full-time at Morehouse, he doesn't need to be working.
Correct. Yes.
Okay.
Judge, thank you.
All right. Ms. Jackson, what criminal history information do you have for Mr. Fields?
Yes, Your Honor. There are 5 cycles. The last arrest was February the 24th, 2024 in Clayton County for driving while license suspended or revoked. He does appear to be on probation in Gwinnett County for possession of marijuana with the intent to distribute. That disposition date was January the 31st, 2024, and the term is for 5 years. He does have misdemeanor convictions. One in 2024 out of Clayton County for driving while license suspended or revoked. One in 2023 out of Morrow, Georgia for knowingly making a false statement pertaining to a motor vehicle insurance requirements. Nothing in addition, Your Honor.
All right, thank you. Ms. Rios,
Yes, Your Honor. Mr. Fields is 25 years old. He doesn't have any children. He has two jobs, which I just provided to you in the fact that he's working at Metro by T-Mobile at the daytime, and then he's doing Domino's, driving for Domino's as delivery at night. That's why the license thing was so important. He did do 3 years at Morehouse. He is planning to go back. This situation has been a hiccup. He's been trying to make money to attend Morehouse, and that's been hard. He did do conditional discharge in one of his other cases, so I believe first offender is still available to him on this case, because the other case was a marijuana case that he took conditional discharge on.
The Gwinnett case, the
Yes.
5 years program.
Yeah, I had him give me the disposition, and it says conditional discharge, so I'm believing that's not the regular first offender. I think that, well, I don't want this case to ruin his life. He wants to finish at Morehouse, have a career. He's been communicates great with me. He's been a really good client. I think this was just a hiccup, and he's going to do great things, and I don't want anything to prevent him from doing that.
Okay. Mr. Fields, what do you want to tell me about what was going on in your life then, when it seems like maybe you had a side hustle that could get you in some trouble, versus what's going on in your life now?
This all starts and hopefully at some point ends with Morehouse. COVID happened during my sophomore year. And so it was a struggle getting through sophomore and junior year. When senior year came, I was basically out of financial aid. And so at the time when I was arrested, I was actually on the way to work at my night job at Amazon at the time. And indeed, I did, try to make more money to college students and everything, to just try to get through and try to fund my college career and potentially pursue sports journalism. And so I got pulled over once, and that also took a turn, and instantly transitioned into just trying to work my butt off, working 2 jobs currently. Don't plan on getting rid of those jobs unless I get a raise or promotion, to eventually complete the mission and finish my last 2 semesters. Got about 30 credit hours. That's been the main goal. I'm not from here, have no family, no support, don't have anybody, putting money in my account. So I'm really just trying to make it work out. And I did make a couple wrong decisions and choices that I quickly noticed it's not the lane or avenue I need to take. And since then, I've kind of been on the straight and narrow, just working hard. And because of that, very big in my religion as well. Because of that, I do feel like God's been blessing me and things have been kind of unfolding the right way by doing things the right way. So as far as that, nothing left to say.
Where are you from?
St. Louis, Missouri.
Do you still have family back there?
All of them, everybody.
No one out here?
Nobody, not even a second cousin.
Sports journalism, is that a major at Morehouse?
Yes, sir. Journalism was the major, minor in sports. That's what I'm pursuing now.
Okay. Did you do anything while there to pursue that? Were you on the announcing games or writing in the paper or what?
Actually, I was a part of the paper, the Maroon Tiger is what we call it. I was just the editor, but it was a good group there. I was also on my freshman year, a part of the football team for that 1 year. We weren't that good, so don't look up the stats. I also got an opportunity for about 1.5 years to be a radio personality from my hometown while I was in here in Atlanta during COVID. Dabbled a little bit in film as well. So a lot of network building in the last couple of years. Just hoping to see, if it could take me somewhere.
When you graduate, is the plan to take those skills back to St. Louis, or you'll go wherever you find something?
Kind of going wherever the best and, most beneficial opportunities present. I doubt it's my small town of St. Louis. Atlanta's a great big city with plenty of opportunity, especially in media. And so we'll see what happens here. Maybe California, maybe somewhere else, wherever the wind takes me for the most part.
Okay. Well, Mr. Fields, I'm going to jump to the end briefly, and then we'll march through the parts you and I need to. You're using up your 9th life here. It sounds like in Gwinnett, you got conditional discharge. You're going to get first offender here. If there's a next time, I hope there's not. It's an F, as in felony, but it'll be an F as in failure too, because that'll be hung around your shoulders. It will define you going forward, and it's not you. And I just share that to let you know you're out of chances. And so if finances get complicated, you have to do a different hustle. Because if you get pulled over and there's dope in the car, there's a gun in the car, that's a felony, and you don't have another switch to pull to say, wait, give me one more chance. So just keep that in mind. It sounds like you've got a good plan for yourself that has you heading in a direction that has nothing to do with this other stuff, which is great. I just hope you're able to achieve that. So I find a factual basis for your plea, and that your plea is knowing and voluntary. Do you agree that no one's forcing you to enter this plea and you understand everything we've been talking about?
Yes, sir.
Good. I am sentencing you pursuant to the Probation Options Management Act. So while you're on probation, if you have a minor violation, and I hope you have none, you and probation will solve that. If it's bigger, you get arrested, something like that, that comes back to me. First offender, the main benefit of first offender is that this is not a conviction. So when you're reapplying to school, applying for another job, you don't have to check that I'm a felon box. But you will still be under sentence. And while you are on probation, either for the 5 years in Gwinnett or whatever you get here, no firearms, nothing like that. The bad part of first offender would be self-inflicted, but if you do get in trouble again, then not only do you have the new charges, but you'd come back here, and depending on the seriousness and nature of whatever that trouble was, I could resentence you up to the maximum. That'd be pretty bad for me to max you out, but you've got a fair number of years, 23 plus the misdemeanor, so 24 years all told if we add it all up. So just keep that in mind. Ms. Rios, can someone in my office sign the indictment on your behalf?
Yes, Your Honor.
Ms. Davis?
Yes, Judge.
And Mr. Fields, can we electronically sign your name indicating guilty plea as to counts 1, 2, and 3, and then a NOLO plea as to count 4?
Yes, sir.
All right, we'll do that. I am going to sentence you on count 1 and 2 to 1 year, and count 4 will be 12 months. Those will all be probated. Count 3 has to be 5 years, and it has to be consecutive. So I'll run it consecutive to count 1, but I'll probate that. That's how we get to 6 years probation. 5 seems to me like it would be plenty, but we can't really do 5 because you've got that consecutive 5 that has to go on top of something that has to be at least 1. 5 plus 1 gets us to 6. 6 years probation. I will require you to submit to a drug and alcohol abuse evaluation. It doesn't sound like that's your issue, but that makes it easy. You'll meet with a healthcare professional who will ask you about what you do in your free time, and if that person thinks you'd benefit from some form of treatment, that treatment is part of your sentence. If that person said, look, you were a marketer but not a user, then there are no issues on that front. But getting treatment is good if you want to achieve your goals. 40 hours community service, you'll need to complete those in your first year of probation. You need to either be working full-time or enrolled as a full-time student. If you're not, for any week that you're not doing that, you'll have an additional 10 hours of community service. All right? But it sounds like working full-time is not hard for you to do. But if you pivot and you're at Morehouse full-time, that'll take care of the, hey, no more additional community service. I think that's it. Ms. Davis, anything else?
No, Your Honor.
Ms. Rios?
Would you be inclined to set a behavioral incident date?
I would not, given that we've got a parallel case running out of Gwinnett where he used his alternate version of first offender. What county do you live in?
Currently DeKalb.
Okay. That just impacts where you were. So are your probation is supervised out of DeKalb?
Yes, when I moved, they switched my
Good.
parole officer.
You're just gonna have one probation officer and he or she, you'll probably keep the one you've got. And that person will be supervising you in both cases, Gwinnett and Fulton. So I guess Mr. Fields is already in your system. Does he still need to report? Okay, so instead of going all the way out to Conyers to say, hey, it's Mr. Fields, they already know who you are, make sure you call whoever your officer is by Friday to say, hey, you got me on another case too.
Okay.
Ms. Simpson will have put the case in the system, so your officer will know exactly what you're talking about. Oh, your Fulton case. Oh, tinted windows and all that kind of stuff, except it's not tinted windows anymore. Any questions?
No, sir.
All right, good luck.
All right, thank you so much.
You bet.
Appreciate you.
I'm gonna step out and try to give Mr. Abadi a
Nope,
call.
you're good.
Yes.
So like the bond hearing may have went because he usually is pretty responsive to my
Okay.
texts.
We are tracking Mr. Abate. That's what we're gonna do next. Oh, he's outside. Excellent. Don't worry, I'm not going anywhere. Let's take stock of other things while we're doing that. So Britton Palmer are bench warrants. What happened to Ms. Bernard? Oh, that was that's a Ms. Cabrera case. And Mr. Ross is a Ms. Cabrera case. Mr. Gould is still a bench warrant? Gould. All right, so if you'd get those bench warrants rolling on Britton, Palmer, and Gould, please. And then Mr. Hardison, we let him go and you'll get me that. Okay. Do you have an update on Mr. Davis?
I'm in line with the body always.
All right, he's not leaving this courtroom for a while. And that's it. Okay. Are you here? Tell me what we're doing on the lemons, et cetera.
That is out of my hands.
Okay, why don't we get some lawyers up here? We'll start, Mr. Regis stood up first, so why don't you come to the podium, sir, and let me know what we're doing with Desmond Hardy.
It is my expectation that Mr. Hardy is interested in entering a plea in that case.
Okay.
If that offer is available still.
Okay. I feel like I'm playing the shuttle diplomat here. Is an offer still available for Mr. Hardy?
There was an offer made for collective responsibility, so.
What does that just translate, meaning all four plead?
Yes.
Okay, and so let's just pretend Mr. Ryder remains aloof from it all. Then no one gets that offer?
That's correct.
Okay. And we start on Monday?
That's correct.
Okay. It sounds like I'm not in the loop on this one. I mean, I'm in the loop, and I appreciate that update. I'm happy to bring a defendant out if that's helpful. Or everyone may want to take Ms. Feely outside and pound on her. And then she could talk to her client. I can, but I'm happy to take 1, 2, 3, or 4, please. The one wild card, of course, is Ms. Cabrera, but my sense is if everyone else is pleading, there's never been an issue with Mr. Lemons. That's her client. But I guess, Ms. Feely, do you want to give me an update as to what's happening with Mr. Ryder?
I spoke with him again this morning and we're ready for trial.
Okay.
I apologize if that messes things up.
You don't need to apologize about anything. It just maybe there are more discussions. Does it help if I talk with Mr. Ryder, or there's no need to help because he knows what's going on?
There's no need to help, but we can go ahead and put it on the record.
Okay.
That he's rejecting this.
Why don't we start with that and then we'll see what flows from that. So if we could, is he up one?
Yeah.
Okay.
Yeah, where's up?
I'll get it.
Thank you. She's doing an ass sledge.
She is.
Well, I have to go out here a while. I think we'll go.
Thursday.
It'll make for not the week I had forecast.
It doesn't matter because he.
Yeah, we need from the big.
Are we bringing everybody up, or just
One.
Right now, we're just bringing Mr. Ryder. It doesn't sound like I would gladly bring your client out, but the point of bringing Mr. Ryder out is to get on the record what the state's offer is. So he is saying, he's telling me on the record, no, thank you to that. It sounds like it's the same offer for everyone, and you're not saying no, thank you to the offer.
If possible, I would like for Mr. Hardy to be out as well, just so that he would know what's going on firsthand rather than having my interpretation of what's happening. I'd like for him to see if that's a possibility.
Can we have Mr. Hardy out here? We'll do it.
Thank you.
This should count as a 10 defendant case.
Stressed out.
If this looks like this, you think it's problematic.
Read it, it's too small.
Yeah, I mean, that's what I explained.
It's 40-6-390.
No little place under your person.
Let me look.
Maybe this is a no.
I think so, but let me check, because I would hate for them.
Yes. Yes.
One more second, Your Honor. Can I come out too? Please?
Yes. Well, not Mr. Lemons. His lawyer is not here. Just 390 is fine. No little letter.
Thank you.
Yep. It's all right.
Good morning, good afternoon. Let me move that. Oh, man. Sorry, please.
Give me 1 second.
That's not what they do. Want to take it like it's not. It's a good trial. It's not going to OD, but that's the situation right now. If your wishes is still take that offer, right, or not? Okay, all right. Let's. That's
Okay, let's get on the record in 22 SC 185-545, which is Ryder, Lemons, Hardy, and Robinson. And we should have Mr. Ryder out here. Is he seated at council table? There he is. Hello, Mr. Ryder. I'm all right. We should have Mr. Hardy here, who is right next to his lawyer.
Yes, Your Honor.
And then Mr. Robinson, who is next to his lawyer. Mr. Lemons is not out here only because his lawyer is in trial next door. But we have 3 of the 4 defendants. Gentlemen, your case is specially set to begin trial on Monday. Each of you is charged with murder. If you are found guilty, you will be sentenced to at least life in prison. You are eligible for life without parole. I don't know that that's what would happen, but if you are found guilty of murder or felony murder, because there are 2 counts of felony murder, those are life sentences. And then there are a few other felonies that could be stacked on top of it. But I want to make sure that everyone is aware of what we're talking about. Murder, felony murder, life, potentially life without parole. I'm going to ask Mr. Abate, the prosecutor, to get on the record what the state is offering. And before he does that, it's my understanding that the offer is one that is contingent upon every defendant taking it. So you're a little bit interlocked here. Normally, there might be an offer, I'm making the numbers up, of 10 years for Mr. Hardy and 7 years for Mr. Robinson. But here the state is offering something that either everyone can take or no one can take. So you may hear it and say, I'd like to do that. But if one of your numbers says, I'm not interested in that, then the state is not making it available to just you. And the state has that authority. They get to offer whatever they want. I don't play a role in what the offers are, and I don't play a role in reducing charges. So it may be an offer to a reduced charge. For example, murder can be reduced to voluntary manslaughter. Only a prosecutor can reduce charges. My role is to then impose a sentence based on what I learned from everyone at a sentencing hearing. So I'm going to have Mr. Abate explain what that offer is, and then I'm going to engage each of the 3 of you to make sure you understand it if you've got any questions about things. And you should know, Mr. Hardy, your lawyer's been keeping me posted about how negotiations have gone and sort of where your mind is. Same with you, Mr. Robinson. Ms. Bumpus has been keeping me posted. And Mr. Ryder, Ms. Feely has been relaying your perspective on this. I just want to get it on the record so that if you decide you want to go to trial and a jury says guilty felony murder, you don't say, wait a minute, what about that offer from the state? Now I'm looking at life in prison. With that, Mr. Abate, what is the state's collective offer?
Yes, Your Honor, the recommendation the state would be making is a reduction to counts 1, 2, and 3 of voluntary manslaughter under 16(5)(2), and plead to the remainder of the indictment. Obviously, the aggravated assaults would merge into count 1, the reduction of murder to voluntary manslaughter. It'd be a global sentence of 25 years to serve, 5 years credit for the time served, commuted to the time served. So everyone would get to go home. And the state said that there's a collective acceptance of responsibility, that the plea could even be non-negotiated, and they could ask Your Honor for whatever sentence they wanted, and my offer would remain the same, it would change.
So you would agree to reduce the 3 murder charges, 2 of them are felony murder, but same sentence, to voluntary manslaughter, all the other things apply. You've let us know your recommendation is 25 to serve 5, but that 5 would be reduced to time served. That's the state's recommendation. If, and I'm not picking on you, Mr. Hardy, you're just the first in the row. Mr. Regis might say, we actually recommend, I guess it's balanced probated. Okay. Mr. Regis might recommend 3 years to serve, full stop. And he could do that, and that wouldn't blow up the plea. Okay. We'd go forward that way. And similarly, Ms. Bumpus could recommend what she wants on behalf of Mr. Robinson, and Ms. Feely would be free to advocate for whatever sentence she wants on behalf of Mr. Ryder. But it, in the end, is a plea to the case. Okay. Mr. Hardy, do you feel like you understand what the state's offer is?
Yes, sir.
Okay. And is that something you are interested in pursuing?
Right with the plea?
Pardon me?
Yes, Your Honor, if I may be allowed to speak.
You
for
sure
that.
can.
That is something he'd be interested in pursuing.
Okay.
Based on previous conversations as well as a conversation this morning.
Okay. He's intrigued by the go home today part of it.
Certainly.
Okay. Ms. Bumpus, same question for you. I didn't mean to not ask you. I should have just asked the lawyer. Ms. Bumpus, same question for you on behalf of Mr. Robinson. Is he interested in pursuing this state's offer of go home today?
Yes, Your Honor.
All right. Ms. Feely, well, let me ask Mr. Ryder, do you understand what the state's offer is?
Yes, I understand.
Okay. So it's go home today. It can be structured differently, but it's go home today Absent the offer, it's come back on Monday and go to trial on the case. If you're acquitted, found not guilty, it's go home a week later than today. But if you're found guilty of the most serious offenses, it's go home in a pine box when you're finally released from jail. You understand that? Yes? Okay, all right. Ms. Feely, what is it that Mr. Ryder wants to do?
We are ready to try.
All right. Where we are, then, Mr. Hardy and Mr. Robinson, is that the state's offer require, and I'll let you all know, I've been told by Mr. Lemons's lawyer that they're on board with this outcome as well. So he's not, his position is similar to the Hardy and the Robinson position. So, the state's offer is contingent upon each of the 4 defendants saying, I'm going to resolve this case this way, as opposed to trial. They're not severing anyone out. And with Mr. Ryder's answer of, I'd rather not go home today, but I'd rather go to trial facing murder charges, then that's what is going to happen. So I don't want to make the lawyers stay here any longer than they have to. Before you take anyone out, Mr. Regis, anything else on behalf of Mr. Hardy?
Nothing. So we are to be here Monday morning. Is that correct, Your Honor?
Yeah, I'll get an email out, I promise. But we're specially set Monday morning. You all told me many weeks ago that this was a week that would work. So it would be Monday, 9 a.m. And the email will include instructions about getting clothes here for Mr. Hardy if he or family has it on the outside. If not, we've got a clothes closet, but you'll just need to let us know.
Yes, Your Honor, we'll be here.
Okay. Ms. Bumpus, anything on behalf of Mr. Robinson?
Your Honor, I would like some more time. Are you gonna take a lunch break?
I am.
And come back?
I'm here all day.
Okay, because I would like to talk to my client, because we may just put it up non-negotiated. I think that may be better than trying to try a case. I'm gonna talk to him about that.
Okay. Well, you can talk with Mr. Abate about that. That doesn't require you to stick around, Mr. Regis, but I will be here. Mr. Abate needs to be here anyway for another matter. So there may be a few more discussions.
We'd like to stick around as well, Your Honor.
Great. We'll keep both of you up here. If you don't come back out, it just means nothing was able to work out, but your lawyers will come talk to you at least one more time before you're brought back to Rice Street. And I'll either see you again today because we've sorted something out, or I'll see you Monday morning and we'll get some jurors in here and they can hear about what happened in the case. All right?
So,
Thank you both, gentlemen. Ms. Feely, before I was turning to Mr. Ryder finally. Anything else we need to cover on behalf of your client?
No, Your Honor, I'll give you that before, because I did bring close to the war, but I'm bring more close tomorrow afternoon. Just to make sure. But
Okay.
We do have some.
Okay.
To start.
All right.
I would have taken that and ran it. Like I'm in jail. Ran out of it.
Mr. Abate, are you able to pivot for a second to Dennis Brenton? Let's do that. Let's bring Mr. Dennis out when you've got a second. I know we're moving people around. And you may want to leave Mr. Ryder on this floor. No? Okay. I mean, it may make sense for people to have conversations back there. Okay, he might have a different weekend. Just give him like 3 minutes with those guys.
Oh, see, the murders are out of my hands. Ag assaults. Help you out. I do my best.
All right, Mr. Bass, is this stuff you want to get on the record, or are we just having a procedural conversation?
Yes,
Yes, on the record?
on the record, yes.
Okay, well, let me get us on the record. This is position 8 on our trial calendar, 24 SC 002038. It's State versus Mr. Dennis, who is here with his lawyer, Mr. Bass. Mr. Abate is the prosecutor. He's here as well. And Mr. Dennis, your case is set to go week 2 of our trial calendar, assuming the 4-defendant murder that was maybe not going to go and now may go doesn't spill into the second week. So that's where we are procedurally. Mr. Bass had flagged a couple motions that he wanted to talk about, and we're going to talk about them. We may not actually litigate them right now because I don't know that the state's on notice, but one of them we may be able to get Mr. Bass heading in a slightly different direction to get the information that he's interested in. Okay? Just to give you some context. Mr. Bass.
Yes, Judge. 2 outstanding issues. One, there is a motion to review the records, documents of the grand jury, including the grand jury questionnaire, just to ascertain and certify for ourselves that everybody who participated in the grand jury process was lawfully and validly present. I filed the motion. I've spoken with the jury clerk, Amy Von Kelch. She has prepared everything. It's ready to be presented. I've asked for an in-camera inspection. I believe all I would need is an order from you to her to produce it to you such that I can review it. So that's my request. I don't know if it's objected to. I don't know if they're standing to object, but.
Well, I always want to hear from the other side, and I'll do that in a minute. But it's my understanding, and I mentioned this to you earlier today, just because I hadn't seen a request like this. You're simply trying to confirm, for example, everyone was at least 18 and was at the time a resident of Fulton County, not what did they talk about in the grand jury? Because of course, we don't have a transcript of grand jury proceedings.
Correct.
Okay. I don't see why you shouldn't be able to see that information. I do think it should flow exactly as you described, where it goes from the jury clerk to me. And I'll look at it first, and there may be a few things I redact. You don't need phone numbers or email addresses. But then I don't see why you shouldn't be able to confirm those things.
Ms. Von Kelch did let me know that you've had problems previous. So I would not be part of a continuing problem with improper disclosure of the information.
Okay, good. Mr. Abadi, I don't know that you really have a dog in the fight, but I do want to see if there's anything from the state about the grand juror qualifications motion.
I have no issue with the way it's been outlined, Your Honor. I don't think I have standing necessarily to object. And if there's something wrong with the qualifications of one of the grand jurors, I'm sure we'll hear about it.
Right, exactly. It may have a ripple effect. You were notified. What was the issue? Was it that there weren't 16? There was an indictment recently with a hiccup.
December.
Yeah.
2024.
Yeah.
There was not enough. There was one less.
Okay, but you guys have scrubbed that list to see what came out through that group. Okay, great. Do you have a proposed order?
I can get it to you today if you wanted me to do it, or if you prefer to do it yourself.
What I prefer is that you email to me a Word version of the proposed order, copy Mr. Abate on the email. I'll massage it, but then I'll just go over to Ms. Von Kelch.
Understood.
I'll get the order into the docket as well. But I'll just get those records, look at them, and then let you know when you can come look at them.
Understood.
Okay, sounds good.
Last issue I have, there was a motion filed by my client, Mr. Dennis's previous attorney, it was a motion to bifurcate, specifically counts 5, 9, and 10 refer to the unlawful possession of a weapon as a felon. They are not related to the murder and felony murder charges. Brief factual statement is the murder, according to the state, occurred outside in a driveway or occurred at a convenience store. There's been no allegation at any point in time that the murder occurred inside the house. Subsequent to the body being discovered, law enforcement executed a warrant, recovered weapons from inside the house that led to the charges of the possession of the weapons. The weapons were not used factually in the death. There's been ballistics. There's been a exam by the medical examiners. None of the weapons are connected to the murder. The only connection to the murder is to infer improperly to the jury that my client is a felon and B, possesses other weapons that are not related to the crime.
I think I follow you. I'm looking at the indictment here. There is obviously a possession of firearm by convicted felon that's inextricably intertwined with the murder because it's a shooting death. And so the state's theory is Mr. Dennis had a gun and he shot and killed Mr. Skelton. So that possession of a firearm is not severed.
Absolutely.
Okay, but then on the same day, it sounds like there was a search warrant or somehow they got into a house and found more guns.
Correct.
And those are being attributed to your client and he's charged with those as well. And those are the ones that you are seeking to bifurcate.
Absolutely.
Okay. Intuitively, that makes sense. I don't know the facts of the case like you do. Mr. Abate, you don't need to commit at this point. I know your focus is on the Lemons et al. Case. What's your initial reaction to that motion?
So that's not how I understood the motion. The motion was asking for counts 4, 5, 9, and 10 to be bifurcated. And because count 4 and count 5 are both felony murders, count 4 is predicated on count 9, count 5 is predicated on count 10. There are no charges that are associated with the additional guns that were located in, or I guess there are no singular charges that are related to the additional firearms that were found in the home. They were just firearms found in the home that were tested against.
This is like Mr. Mosley's case. Mr. Dennis has a prior conviction that triggers a separate possession of firearm by convicted felon?
131 and 133.
Okay.
Both predicate offenses for the 2 felony murder counts.
Okay, so it's that firearm that was allegedly used to kill Mr. Skelton that is clearly it's the basis of the felony murders, but they are linked to counts 9 and 10, which are same gun, different convictions because it's a different element and frankly, it's a different crime, similar crime, but different crime. So you're saying there's not a count in the indictment that is, oh, and by the way, you also were a felon in possession of this gun that we found in the house and this other gun that we found in the trunk of your car. Okay. If that is the state of the evidence that the state's gonna seek to present, I don't know that severance is appropriate, but again, I wasn't expecting us to fully litigate it, just sort of to get a sense of where we are. That sounds like a different set of facts.
Legally, I can't object to them using the gun charge in a felony murder where the weapon was a gun.
Right.
However, for example, body cam footage of SWAT team going into the house, seeing a rifle. Rifle is not related.
Okay, so
Testifying.
got it. It may be that your motion is more of a motion in limine to exclude evidence about what was found in the house. It's sort of like if what comes up more often is someone is accused of murder, they're arrested 5 days later, and he's got marijuana in his pocket.
Right.
And drugs have nothing to do with the murder. That marijuana typically doesn't come in as evidence because it's not relevant to, did you shoot this guy 4 days before? And so a rifle being in a residence associated with Mr. Dennis, arguably, there could be a counterpoint, don't have anything to do with, did Mr. Dennis shoot Mr. Skelton earlier that day or whatnot. But importantly, none of those firearms seems to be the basis for any charge in the indictment, as the state tells me it's going to present the case.
Understood. And with that presentation, it would seem that the probative value is greatly overcome by the prejudice by introducing the evidence of the weapons inside the house.
Okay, got it. So what I'm going to ask you to do.
Your motion in limine.
Exactly. And so I'm not going to treat it as a severance motion anymore. I don't think that's where we are. But there may well be things from body cam, testimony that might come from a witness that you seek to exclude that relates to the arrest or the search of the house. That's a 403 issue.
Exactly.
And so why don't you tee that up with a motion in limine? And then we would talk about that the day we pick a jury, because we have a good window of time before the jurors make it into the room to work through that. And if for some reason I have to do some research based on your motion, I'd probably get it done before we start openings the next day. But worst case scenario, I would just tell the state, I still haven't figured out, don't talk about that in your opening, because I may yet exclude, we found 9 assault rifles under Mr. Dennis's bed, because that may be something that is precisely violative of 403. Okay?
Understood.
All right.
Just for my clarity, you still should have the clothes I brought for the first week, correct?
When you brought clothes, oh, they went.
So you might.
Yeah, we will look for they are not lost, but Mr. Dennis, because you have been very persistent on behalf of Mr. Dennis to get him into court, I put his case on that consolidated calendar because I might be busy, but we can get another judge to try it. And so you brought the clothes, you may have brought them here, but they went down to 1D. So we will look for them. They're not lost. I just got to put our hands on them.
And last,
it's not for next Monday anyway, so we got a minute to find them.
And last I saw, to help you find it, it was a white Georgia Armani bag.
Yeah.
Ooh, it's nice clothes. Okay. Sweet. I know how Mr. Dennis rolls. All right. Anything else?
Not from defense.
Okay. All right. I'll keep you posted via email. We need to see what happens with our 4 defendant murder, if it goes, how long it will take, et cetera. But your case will be on the short list for Monday, the 21st. Okay. All right.
On the short list, what that mean?
So I don't ever just bring in one case because defense attorney gets sick, detective is injured, someone pleads guilty. So I'll be bringing in maybe 2 or 3 cases for that Monday. And then we see who's ready and who's not. Okay?
Thank you, Judge.
You're welcome.
They're going to take you back. I'll come see you. You can go right now. Excuse me.
Yes, sir. Appreciate your patience. Ms. Cabrera.
I'm here, but I'm not.
I understand.
So we're on our lunch break.
And I'm about to start mine.
Okay, you want to run through the calendar?
I do, just real quickly, and then they may swarm you, and then you may want to go up to the 9th floor and talk to Mr. Ryder.
Yes. It sounds like I have so many issues.
So Mr. Palmer didn't show.
Oh, okay.
Nor did Ms. Britton, and they're sort of together-ish, and so it doesn't surprise me that if one didn't make it, the other didn't make it.
So Mr. Palmer has offered that I think we have, I think I asked the state about probation. And at all probation, he was willing to do that. So he would have been
Yep,
So I'll reach out to him
Great.
and find out where.
if he walks in with you or an associate, then we can make the bench warrant go away, but for now, there's a bench warrant.
Okay, I'll send him a message, but that was a yes on the plea.
Okay, you have Mr. Baker, but Mr. Baker's not going anywhere right away because we have to deal with Mr. Pierce's various motions, and I will do that. Ms. Bernard, are you still here, Ms. Bernard? Ms. Bernard is still here.
Wasn't that a diversion?
You have to ask Ms. Davis.
I don't believe so. I think she was denied, I want to say. In other words, two that were diversion offers.
Well, you interestingly have two defendants in that case.
I do.
You also have Mr. Ross, who is here, and he was offered diversion. And it's just a question of whether.
I just need to tell him about it.
Okay.
I can't imagine he's gonna say no.
Okay,
And so I will tell him about that, and then I don't know what the next steps are because he's in custody. Do we know when he's getting out by chance?
well, if he's in on us, we'll get him out.
We got him.
If he's in on other things, I know he had some other business at one point, but if all that remains is this, then I'll get him out into diversion. Okay. And that was it, other than, of course, Mr. Lemons.
Okay.
And so just I had Mr. Ryder, Mr. Hardy, and Mr. Robinson all out here to explain what the offer is and how it's a collective offer and they're all connected. And Mr. Hardy said, I'm good with that, effectively through counsel. Mr. Robinson said, I'm good with that. I let them know that Mr. Lemons through counsel had said, I too am good with that, just in case they bump into each other somewhere, they can know where they're standing. And Mr. Ryder made very clear he ain't good with that. That's where we are on that one.
Okay, so I don't know, up to Ms. Fields if she wants me to speak on or not. I don't know.
You guys can sort all that stuff out. I'm gonna go take a lunch break, and we're gonna reconvene. Tell me what you've got left, Ms. Wood.
Mr. Davis, and I'm gonna speak with Mr. Bonnie.
Great. You have a good window to do that. Ms. Rios, you could look like you have your backpack on. You're done? Yeah. You got your walking stick, your running shoes. Okay. Because there seem to be a lot of folks here, but maybe they're all here for the Hardy Lemons Ryder situation. Okay. Is there anyone here whose case I've never talked about?
She's here.
Okay.
Yeah.
So Mr. Baker's co-defendant is Mr. Pierce. And he has a few motions I still need to work through before we can do the trial.
And if she wanted to play first offender, she can.
Can we get a more treatment for his eviction please?
Sure, you should, if you get a chance, yeah, and I wanna just, in defense of Ms. Cabrera, she's been stuck in trial the last 4, good, okay, as long as you've been talking. If she reaches out to me, I'm happy to reach out to the medical staff at the jail, to not tell them how to do their job. I'm not a doctor, but I could say there's a concern about Mr. Baker. Could you guys just let me know what's going on? Because yes is the answer. We need to pay attention to that.
So Jen, I'll send you an email. Miss Cabrera she talked to me about it, so I can send an email with everybody on it as well.
Good.
That way you get an email with an update as to what Mr. Baker's issue was.
Okay, good.
All right, Judge, what you had, go through those motions, is he still gonna have a bond hearing today?
No one was having a bond hearing today. Okay? All right. That's it. So, yes, sir. Yeah, so Ms. Bernard's lawyer is right here. I'm gonna have you guys talk. And if that's not a case that's working out today, then you're free to go. I just need you to talk real briefly with Ms. Cabrera, okay?
Okay, so I'll speak to Ms. Bernard. I have her offer.
Good.
That she was referred for diversion, denied for diversion, but there is an alternate offer. It does include probation.
Okay.
So I'll speak with her, but I want to make sure that I speak to anybody in the back because Ms. Bernard can actually walk and talk with me.
Right. So Mr. Ross is back there. Mr. Lemons, although my guess is that Hardy and Robinson have let him know what's going on and not going on. And I really encouraged them to put Ryder in the same room with them, but they said no. So, here we
Let
are.
me talk, to, Mr. Ross and pass him that recommendation, because I think that'll be resolved, and then whatever Your Honor wanted to do to have him released.
Yeah, if you convey to Ms. Davis that he's doing diversion, then she'll do the magic order. When I see that magic order, I'll do what I need to do to get him out.
Okay, all right, perfect. I mean, pop in the back.
Can I
and
just-
Mr. Nardi, just wait.
Ask for clarity purposes, the family members for Ms. Santos, who is the victim in Mr. Davis's case, should they stay around?
Yes.
Okay.
Okay. All right. So for more clarity purposes, I'll be back at 2. So we'll take an hour lunch break. And then we will take up whatever we're taking up. That gives Mr. Regis and Ms. Bumpus opportunities to see what they can sort out. And then we'll take things in whatever order you want to take it at 2 o'clock. Okay? Thank you.
So we said, yeah, okay, to diversion, yeah, you guys let us know by email. Yeah.
Yeah, 1 second.
I did. I'm sure you did. I don't know her.
Is that person's name?
Michael Lyle. It's literally, I think it's very.
is because like
Are you Deputy Gordon?
Well, 5 and 6,
Did they?
yes.
Huh, okay. Ms. Britton? Good afternoon. When'd you get here? At 1 o'clock? Okay. Ms. Rios knows?
Yes, Coach.
Okay.
Yes.
Okay. You have your backpack on still? No? Okay. And then Mr. Palmer? When did you get here? Okay. If you had to guess, what time do you think the calendar was?
We're going to the paper I got screenshot on, getting me the dates. So I was going off the passport date.
Okay. You guys should take a seat and we'll talk about your cases in a little bit. No Mr. Gould, though. Still no Mr. Gould. All right. I don't see any of the Lemons. Right. Well, I see Ms. Feely, the source of all our woe. Client management at its best. Okay, and you don't need to grab her yet. I mean, we can't do anything without the prosecutor, and I've been told he's working his way this way.
All right.
Do you have an update? Nope. Okay.
I've represented Mr. Ryder for a long time, this is,
All right.
surprised to me, apparently it's process.
I have no idea. I'm just here to facilitate resolution. Ms. Rios, what are we doing with Ms. Britton? You're on mute.
Sorry. So Miss Britton, and it's partially my fault that she's not here. I was calling the wrong number. I forgot the last time we. Oh.
The last time you what?
I'm sorry. The last time I talked to her, I had the wrong number. And so she gave me a new number, but I did not save it. So that was my fault. I should have texted her this morning. I was texting the wrong number. So that's why she didn't know to be here at 9 o'clock. I usually have better communication.
Okay.
But
so that's part one, and she's here, so we're past that. It's good she's here. Same with Mr. Palmer. We're all clear on that front. What are we doing? Ms. Britton has two cases, one with Mr. Palmer and one just on her own.
We're going to refer her to mental health court. Haven't had enough thorough conversations with her, but I did talk to her when we were on the break, and there's some information that I didn't know before, and I think she would be a really good candidate for
BHTC?
Yes.
Okay. And that's something you discussed with Ms. Britton, at least preliminarily?
Yes.
Okay. And Ms. Davis, is that something that you have discussed with Ms. Rios?
Yes, we spoke over the break about it.
Okay.
And we hope to include the third unindicted case as well.
And what are those kinds of charges?
That they're all kind of,
Okay. And would this be I don't remember what we used to call it, so I won't call it track. This would be a plea to those three cases into BHTC or TBD?
I'm hoping diversion.
Okay. Well, it sounds like you and Ms. Davis need to talk about that as to how that's going to play out. It sounds like the most important part is connecting Ms. Britton with some supportive resources, which is exactly what BHTC would be. But it sounds like she hasn't had an intake interview. Is that correct?
No, and I will do the referral today. And I actually talked to Miss Warrior. Am I saying her name right?
Ms. Wart?
Miss Wart about it, because we're going to need some help getting her medical information. And so she said that they can help with that.
Okay. Do we have the third case number? I've got a 23 SC and a 24 SC.
It should be 24 PI.
Oh, it's not indicted yet.
No, it was unindicted.
Oh, okay. All right. I don't need it then. Ms. Britton, why don't you come up to the podium, please? It's safe. Just come on up. Don't worry. But that way you can see Ms. Rios and she can see you. Okay?
Okay.
All right. Excuse me. So it sounds like, Ms. Britton, we're not going to be able to do anything with your cases today. But soon you're going to have a meeting with someone from our accountability courts that person's going to talk to you a little bit about where you are in life right now and what you might benefit from in terms of getting some support. Are you willing to have that conversation?
Yes, sir.
Okay. Ms. Rios, in your experience, does that mean that Ms. Britton comes to Hope Hall, that someone calls her, they meet her? How do these intake interviews happen?
They call her.
Okay, so it's a phone interview. And you'll fill out the referral paperwork today?
Yes, Your Honor.
Okay, and for now, just include the PI number. If that ends up being an accusation, we'll turn it into an SC number, but let's at least figure out, is BHTC the right fit? In other words, will they take Ms. Britton's cases? And if the answer is yes, then I'm gonna ask you and Ms. Davis to finish your negotiations as to whether it's a diversionary track or it's a plea track. Ms. Britton, have you ever pled guilty to a case before?
No, sir.
No, sir. Okay. So you have no convictions?
No, sir.
All right. I know you've been arrested a few times in connection with this. How many times would you say you've been arrested?
I say I've been arrested like 7 times.
Okay. Ms. Jackson, do you have criminal history information for Ms. Britton?
Yes, Your Honor.
Does she have any felony convictions?
There are no convictions, Your Honor, listed in the GCIC.
No misdemeanors either?
No, sir. It's just like she has a hold out of Houston, Texas, for a failure to appear, and that was February the 6th, 2025.
Okay. All right. Thank you.
Yes, sir.
You've been to Houston, Texas before?
Yes, but I was incarcerated, and when I was incarcerated in Atlanta, they had put a warrant out on me because I wasn't able to make it to that.
Got it. You had a court date, but you couldn't go because you were stuck here.
Yes,
All
correct.
right. Well, I hope they clear that up out in Houston. That's neither here nor there. What's there? It's in Houston. But all right. So what's a reasonable timeline, Ms. Rios? I don't want us to sort of lose track of Ms. Britton and her 3 cases.
Can we do the September calendar? Only just because if it's her medical records were at a hospital that closed down. So we might have to, when I talked to Ms. Ward, she said we might have to send her somewhere else that can do an evaluation if we can't find her mental health diagnosis records.
Okay. So, but you think just moving it to the September trial, I guess, because it's on a trial calendar. I don't know why we put it on something else.
Yeah, I think September trial calendar.
Okay. Ms. Davis, you will between now and then think about what the state's going to do about the unindicted case?
Yes, it's my understanding, we did this for, I don't know if you recall the Mr. Crowder case. It was a behavioral.
Felix Crowder, yeah.
Yes, and one of the unindicted cases was able to be admitted just like that.
It can, and so there's no, I don't mean to tax, yeah, I didn't mean to talk over you, sorry. Go ahead.
Oh, no, Judge, you go ahead.
Okay, I'll go first, except you were already going, so I apologize. I didn't mean to suggest that you had to accuse or charge it. If the end game is, the goal is BHTC, then it's perfectly okay to have it go in unindicted. That ensures that it's a diversionary case. What you decide as to the other 2, we've got now a couple months to work through that. Okay. Ms. Britton, do you feel like you've understood what we've been talking about?
Yes, sir.
You know you've got a 3rd case that's not indicted yet.
Correct.
Okay, what's that one about?
It's I think theft.
Okay, but like, was it a car or food or a
By receiving.
theft by receiving? So you were in a car that was a stolen car?
Yes.
Okay, all right. So that one may remain not charged. If you get into the behavioral health treatment court, the charges will go in there, but if you do fine in that treatment court, then the state will just dismiss those charges. I don't know what's going to happen with the two indicted cases. There's the old drug case and the also old, but not quite as old, aggravated assault charge that you've got. But the most important thing is you're going to get a call in the next few days from the accountability courts to talk to you a little bit about your situation. Just make sure you engage with those folks, okay?
Okay.
All right. Ms. Rios, anything else on behalf of Ms. Britton?
No, Your Honor. Thank you.
Okay. So you'll get that referral today?
Yes, I'm gonna do it as soon as we get off the Zoom. I get off the Zoom.
All right. Sounds good.
All right, bye for real this time.
Okay. So you think, before you go, do you have any questions about anything, Ms. Britton?
No, sir.
Okay. Do you have a good phone number for Ms. Rios?
Yes.
Pardon me?
Yes, I do.
Okay, great. All right. Bye, Ms. Rios.
Bye.
So, Ms. Britton, you are free to go. If you came here with Mr. Palmer, then you need to stick around for a minute because I have to talk with him real briefly. And then we'll see what happens with the accountability courts, okay?
Okay, thank you so much.
All right. Mr. Palmer, if you'd come up here, please. How you doing?
I'm all right.
Okay. You've got a couple cases as well. We are not going to talk substantively about them because your lawyer's not here. She's actually right next door in a trial. And she did swing by earlier this morning and was disappointed that you weren't here. And Ms. Davis, I'm not remembering, had she and you reached some kind of agreement on Mr. Palmer's two cases?
We had, it's my understanding
Whoa,
that.
Ms. Bumpus just stood up. Okay, did you talk with Ms. Cabrera about Mr. Palmer's cases? Got it, okay, great, thank you. Ms. Davis, tell me, remind me, please, what you shared with me about your conversations with Ms. Cabrera.
Oh, yes, it was an offer for 5 years to serve 10 months. It's my understanding Mr. Palmer spent about 45 days in custody here, and because of the new offense was revoked about 9 months right after. And so giving him credit for those times that he was incarcerated, the balance on probation with are just normal standard terms.
Okay, and that would resolve both.
Cases.
He's got the case with Ms. Britton, the drug case, and then his other case is another drug case.
Yeah.
Okay, all right. Ms. Cabrera's been in this trial for 4 weeks now, so it has, you may have been trying to reach her, she may have been trying to reach you. She is generally very responsive, but this has been quite the trial. Have you had a chance to talk with her about your cases?
Not about the case, but about the dates and everything that was coming up, but not about the case itself in general.
Okay, all right. So, Ms. Bumpus, you said you would figure out if there's a break coming up, or I didn't, other than it, you.
I do remember you said it's gonna be a probation sentence and she was gonna communicate that.
Okay.
Whatever you need to do.
Okay, well, I don't know when they're gonna be on a break, but I guess, yeah, I guess if you'd let her know, that Mr. Palmer made it so that if she's got a break, she could come over here. I'd just like for them to connect today, even if then in the end, they say, we need a little time to work through this. I don't think this one will need to wait till the September calendar, for us to do it, so that would be great. Thank you. So, Mr. Palmer, I'm gonna have you take a seat, and we'll see if we can get Ms. Cabrera during a break to come. Most importantly, talk with you, but after she talks with you, she may have an update from me. Okay, sir? All right.
Thank you.
All right, Mr. Abate is here. Do you want to talk about Mr. Davis first or the 4 amigos first?
Whichever.
Or 3 amigos plus Mr. Ryder?
Whichever, doesn't matter.
Well, Ms. Wood, let's talk about Mr. Davis.
We are still talking to Mr. Abadi, so it's not gonna resolve today. So I know it'll stay on the trial calendar, but I'm really confident it's not gonna resolve for the trial judge.
Okay. This would be the other case, Mr. Dennis and Mr. Davis would be the ones for the second week. And we'd figure out far enough in advance, so you're prepping for the right one, whether it's Dennis or Davis. But I want to keep Mr. Davis focused, so you should let him know. I'm happy to bring him out if you think we need to.
Consider that.
Okay, all right. Mr. Body, anything else on Mr. Davis's case?
No, Your Honor. Ms. Cabrera just texted me and she said that Ms. Thomas, if she could, she would be thankful for her taking plea on the last client.
Okay, on Mr. Palmer.
Yes.
Okay. Well, why don't we do this first, just to close the loop on Davis. We'll make sure he's brought over, not this coming Monday, but the Monday after. And whatever offers are being discussed would resolve, what would it just be? Accusing or is the new case indicted? The new CODIS hit, is that indicted, or there'd be an accusation, or it just would be a plea to an amount maybe longer than only for the murder and sexual assault, to incorporate that, or where are we with that?
I think it would probably be an indictment. Grand jury's been down since the term for the last one just ended. I think they come back on Monday, so it would be probably next week if we were coming to a resolution.
Okay.
Where I would re-indict. I want to be problematic for Miss Wood if to waive an accusation on a rape. So
Got it. And so you would just do a new indictment that actually had both incidents in it. And assuming it's a plea, there's no joinder issue there. Okay. All right. So I guess that's, you're gonna see what happens with Mr. Davis. Sounds like a plan. All right. So Ms. Davis, would you mind talking with Ms. Bumpus about Mr. Palmer's cases so that Ms. Bumpus and Mr. Palmer can talk to see if that's something he wants to try to sort out today?
Understood.
Does that make sense?
Yes, Judge.
Great.
I'm sorry, but Ms. Pinar is there and she's wondering if we can make her please.
Oh, yes, let's talk. Thank you. You are doing a great impression of Ms. Cabrera today. Ms. Davis, how did you leave that? When I left, Ms. Cabrera was still sort of floating around here. So the question is with Ms. Bernard, how you left that with Ms. Cabrera, because it may be, again, Ms. Bumpus could be counsel of record. Oh, so Bernard's ready to go. Okay, so why don't we do this? If you would talk with Ms. Bumpus about Mr. Palmer's cases, then we'll do Ms. Bernard's plea, and then we'll see what we end up doing with Mr. Palmer's cases. Okay, great. You may. Thanks for being here. So for you are next week.
Yes.
Holiday and Rose, I think is what we've got. Although what happened, I'm curious about this list. So that took care of Ms. So Ms. Bernard's gonna be Gould, was a no-show. What about? Oh, Mr. Hardison was VP. So
I was
you,
about to do that order right now.
okay,
I forgot.
cool.
Yeah.
You'll do that one. Rose, we've covered. Fields, Led, and Hassan is not till September. And then Nelson was a plea. Great. Okay, yes, you're free to go once you get me that VPTI.
I will do that.
Is Mr. Regis still around?
He said he's coming back.
Good, okay.
Chief or from board community service.
Ms. Davis, I got your email about Mr. Ross. It sounds like he said yes to that. Is he still here? You just send people home when you want to send people home?
He said yes.
Okay. But we need to figure out how to get him out now then. All right. My project. Thanks.
He said he wanted to do it. As long as he don't have no classes.
Can't control that.
I mean, no, I said if you don't have a trip, we won't have to do it.
I'll wait till you finish. Email you, make an announcement.
Oh, say has Reagan's number? Oh, you know his number, okay. Yes, ma'am. I have his email. Oh, she called. Not on that other email. The public defender one. Not that one. That's what you're saying.
This is whatever kind of ID.
Oh, his iCloud.
That always, it's how you can make that tell whole message me.
He's always right. You don't know him? No. It's fun, honey, one thing, nothing else to her, whatever happened. I have never heard no bullshit like this and that. That's definitely not. Like, I don't even want to go to church. I just want to go home.
Well, when a client could go home.
That's what I'm talking about.
That's when I went there.
I think he on them K-12 strip that, you know what that is? Yeah.
What is it?
Who? Yeah.
Judge?
Ms. Davis.
Yes, I believe Ms. Bumpus is ready to proceed on both of the pleas whenever you're ready.
Well, I'm ready. Are we on the Ryder et al. Case? We'll take these pleas first, but then I guess we'll just need to have a final base touching for those defendants. Does that work for you? Okay. All right. Then why don't we do Ms. Bernard first, because you asked for her first and she's been here longer. Mr. Palmer is a late arrival. So Ms. Bernard, if you come on up to the podium, please. know when you're ready.
I'm ready.
Okay. Ms. Rivers, you good? All right, this is position 20, State versus Bernard, 24 SC 005867. Ms. Bernard is here, and Ms. Bernard is, for the purposes of this plea, being represented by Ms. Bumpus, who is standing in for Ms. Cabrera. Ms. Davis is here for the state. Ms. Bernard, in just a moment, Ms. Davis is going to put you under oath and ask you some questions about you and your case. You need to answer those truthfully and completely. You should let me or Ms. Bumpus know if you have any questions of your own. Will you do that?
Yes, sir.
Okay. And I want to talk about representation. Ms. Cabrera was the lawyer appointed to represent you. She is, as you know, we talked about it before, in trial right next door. And she has a friend and colleague, Ms. Bumpus, who is also a lawyer, who has agreed to stand in for Ms. Cabrera as your advocate and counselor for purposes of this plea. Are you okay moving forward with Ms. Bumpus by your side?
Yes.
Great. You can ask her the same kinds of questions you'd ask Ms. Cabrera. Anything you say to Ms. Bumpus that we can't hear is private and confidential. That same privilege that you enjoy with Ms. Cabrera, you'll enjoy with Ms. Bumpus. Okay?
Okay.
All right, let's get started.
Ms. Bernard, please raise your right hand. Do you swear or affirm the testimony that you will give in the matter before the court shall be the whole truth and nothing but the truth?
Yes, ma'am.
Okay, you can put your hand down. Please state your true and correct legal name.
Tashay Bernard,
Can you spell your first name for the record?
TYSHEA.
Are you at this time under the influence of any alcohol, drugs, or medication?
No.
Is there any medication that you normally take that you have not taken today?
No.
How old are you and how far have you gone in school?
I'm 26 and I graduate high school.
Which high school did you attend?
Tri-Cities.
Nice. Are you able to read, write, and understand the English language?
Yes.
Are you a United States citizen?
Yes.
Do you understand that you're charged with the following offense: theft by receiving stolen property, and Judge, the state is moving to null pros the burglary in the first degree? I'm not sure if you remember that this is a three-party co-defendant case. Mr. Martin did take responsibility for the burglary. He was actually the main person found with the items that were tied to that burglary.
Got it. And Ms. Bernard and Mr. Ross were somehow associated
vehicle.
with him. Okay. Oh, sitting in the car.
Yes.
All right.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your lawyer, Ms. Cabrera, and Ms. Bumpus about all the facts and circumstances known to you regarding this indictment and any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes.
Ms. Bumpus, do you waive formal reading of the indictment and any and all defects therein for the purposes of this plea?
So like,
Ms. Bernard, do you remember having been arrested on these charges?
Yes.
Your Honor, the state's unaware of any outstanding warrants related to this matter. Ms. Bumpus, are you aware of any outstanding warrants?
no. Excuse me.
Ms. Bernard, has your attorney advised you of the minimum and maximum sentence for the charge to which you're pleading to today?
Yes.
And I believe based on the value of the goods, it was a stolen vehicle, the maximum sentence would be 10 years.
Understand?
Do you understand that today you're entering a negotiated plea of guilty, which means the state will recommend a sentence to the court? You have to
Yes.
say it verbally.
Huh?
You have to say it verbally.
Verbally?
Yes.
Verbally.
Yes.
You have to say it out loud.
Just out loud. Whatever your answer is. You're welcome to nod your head or shake your head, but then it's yes or no, or what are you talking about? Whatever your response is, okay?
Yes.
Thank you. Oh, that was very loud.
Thank you. Do you understand the court is not required to accept the state's recommended sentence?
Yes.
Do you understand the court has a right to sentence you to the maximum possible sentence on the charge?
Yes.
Ms. Bumpus, do you know if Ms. Bernard is pleading under first offender?
She is requesting first offender treatment.
Ms. Bernard, are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pleaded guilty or no to or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony or misdemeanor under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Yes,
Yes.
I think so, yes.
Did she explain it to you?
What my case?
No. What happens if you plead on the first offender?
No.
What was your question?
So,
Did your lawyer explain the First Offender Act?
probation all the time.
Mhm.
And you can say that you're not a first offender can be taken, and you can be resent. That's no more.
Okay,
Do you understand that?
yes,
You can go in trouble again.
no,
You could tell someone kind of like, if you're gonna be in trouble again, just don't take it.
okay.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked and you could be adjudicated guilty and you could be resentenced up to the maximum sentence for the charge on this indictment?
You understand, yes or
Yeah,
no?
yes,
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including federal courts?
yes,
I speak up.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? That's true regardless of any advice by your attorney or anyone else.
yes,
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you'll be guilty of a felony, which may carry a sentence from 1 to 15 years in prison?
yes,
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial?
yes,
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
yes,
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
yes,
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury,
yes,
the right to remain silent and not incriminate yourself,
yes,
the right to confront witnesses against you,
yes,
the right to the assistance of counsel hired by you or court-appointed counsel if you cannot afford an attorney at a trial of your case,
yes,
the right to the presumption of innocence,
yes,
the right to testify on your own behalf and to present other evidence,
yes,
the right to subpoena witnesses and compel the production of evidence,
yes,
the right to have the charges
Yes.
against you proved beyond a reasonable doubt,
yes,
the right to appeal if convicted of these charges after a trial.
yes,
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
yes,
Do you understand that you have only 4 years from today for this felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
yes.
How do you plead to the charges in indictment 24 SC 005867, theft by receiving stolen property?
Mm,
What's wrong? You're not sure?
Yeah, I'm not
Okay,
sure.
hold on, excuse me.
Okay.
Okay, she would like to stop for a second. I don't know what's going on. I don't know if we want to talk right here or just move on.
So we will stop. So Ms. Bernard, we only go forward if you're comfortable going forward. And it may be in the end that what you want to do, and you should talk with Ms. Bumpus about this, is enter what's called an offered plea, which is when a defendant, someone in your situation says, Judge, I think it's in my best interest to take this deal. I don't want to go to trial, but I'm not admitting that I did all the things the state said happened. It sounds like you were there and maybe you were in a car, maybe you didn't know the car was stolen, and that might be a defense, but you also may not want to go to trial because that scares you of what could happen there. I don't know what this jury's going to do. And people enter offered pleas, and I can accept that. It's just your way of saying it didn't go down the way the state said it went down. But I don't want
It's on a break. Can I let her answer the phone for?
Sure.
Ms. Cabrera?
Yeah.
I'm sorry, I didn't.
No, that's okay.
There you go. She's calling you. Go ahead. Just step.
Yeah, you guys step away from the mic and you can talk.
No, it's not.
Okay. Okay.
You ever heard of Harold's Chicken and Ice?
Yes.
No, we just got a big lawsuit over that.
Oh.
Big money. Apparently that makes a lot of money and the business partners are fighting over it. I'd never heard of it.
Oh, very popular.
The one over there.
It's on Edgewood. It's near here.
Yeah, they have multiple locations.
We may have to go check it out. Yeah, it's I didn't realize it's a franchise. I won't call it a chain. There's more than one.
Got some good ones.
Okay.
Is it still on Edgewood? For whatever reason, I
Right
thought
here.
that one closed, but maybe.
349 Edgewood.
Okay.
And that's what the
Sure.
lawsuit is all about. But you could get us food from there. That's close
Good
by.
time. I mean,
We're done?
okay.
Okay.
So, Attorney Cabrera asked that she just, be given time to speak with her and go
Sure.
over everything again
Yeah.
and put her on the next available calendar, because she's not 100% sure.
Okay. Got it. That's what we'll do. So we'll move it to the August calendar. Hopefully Ms. Cabrera will be done by then.
They got 2 more witnesses.
That's what they say.
No, they said 4. Oh, no, the state got 2.
Yes.
And the defense got 4.
Yeah, I mean, I would think they'd finish this week, early next week, and then the jury can do its thing. Cash out?
Does Mr. Palmer need to speak with Ms. Cabrera?
No, she said he's ready to go.
Mr. Palmer, you good to go?
Just,
You sure?
if you're not, just let us know.
What did he say?
He said he's good to go.
Come on up.
Oh, is she excused?
I just want to talk to her, so I sort of thought she had left. I talked to her. Okay, have her come in for 1 sec, please. Harold's Chicken. They have sweet potato tater tots.
That sounds good.
That sounds good.
That sounds really good.
A lot of fish. Hey, Ms. Bernard, we're not on the record anymore. I just wanted to make sure I understood what was going on. You want to take a break and you want a chance to talk with Ms. Cabrera a little more about the case. Is that right?
Yes.
Okay. Since she's in trial, what I'm going to do is, I'm going to keep your case on this trial calendar because Ms. Cabrera might finish early enough, not today, not tomorrow, but in the next few days, that she could still connect with you during this trial calendar. But if not, you'll be back on the August trial calendar, which is only about a month away. So you need to come back here for that. And you're always welcome to have a trial. You've got an absolute right for the jury to hear all about what was going on. You'd be the only one going to trial. Mr. Martin has pled, Mr. Ross has resolved the case. We'll bring you back at the latest for that August calendar. But we could just do what we did today, but finish it all the way through, whether it's an offered plea or whatever you and Ms. Cabrera sort out, okay?
Okay.
Does Ms. Cabrera have a good phone number for you now?
Yes.
Okay, well, Ms. Bumpus does. She'll get that to Ms. Cabrera. Do you have any questions for me?
No.
Okay, well, I appreciate you staying here all day. I know that was a lot of waiting around. I had thought you were ready to go forward, but you need to be ready to go all the way through. And if you're not, then we'll see you soon. Who did you bring with you?
Who is he? Who is he to you?
Her fiance.
Her fiance.
Okay, great. All right, well, maybe he'll be with you when you come back, all right?
Okay.
Take care.
Thank you.
You gotta ask, because I almost said, is that your dad?
I did too.
But I didn't.
Glad you asked.
Yep, because I've learned it's not Coolio.
It's definitely not Coolio.
Cash App. All right, if you can come on up again, Ms. Bumpus, we'll see if we get through with Mr. Palmer. Mr. Palmer, you ready?
Yes, sir.
We're gonna get on the record in your two cases. You are position 6 and 7, back to back. I won't read the numbers, they'll be on the docket. You are, for purposes of your plea hearing, being represented by Ms. Bumpus, who is a friend and colleague of Ms. Cabrera's. And I want to make sure you're okay having Ms. Bumpus standing by your side instead of Ms. Cabrera for the plea.
Yes, sir.
Yes, okay. Ms. Davis is going to put you under oath in just a moment, ask you a bunch of questions. You need to answer those verbally so we can hear you and truthfully. But I also need you to let me or Ms. Bumpus know if you've got questions of your own. Will you do that?
Yes, sir, I will.
Excellent. And we're in a good spot. Ms. Davis?
Please raise your right hand. Do you swear or affirm the testimony you will give in the matter before the court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Excuse me, Judge, I'm sorry, can I sit down until it's my turn?
You sure can.
Thank you.
You can put now that you've been sworn in, you can put your hand down. The fact that Ms. Bumpus is sitting is good for her. She should be sitting. But if you need to talk with her, just walk right back there and talk with her. She's not abandoning you. Okay?
Yes, sir.
All right.
Okay. Please state your true, correct, and legal name for the record.
Corbina Omar Winston Palmer.
Okay, I'm gonna ask you to spell your first and then your middle name for the record.
Yes, ma'am. Corbina is Kwabena.
Okay, and your middle name?
Winston, Winston.
I had an Omar down here.
Omar and Winston.
Oh, you have two middle names.
Okay.
Which comes first, Winston or Omar?
Omar comes first.
Okay. And then Winston and then Palmer.
Yes, sir.
All right. It's a long name.
Are you at this time under the influence of any alcohol, drugs, or medication?
No,
Is there any medication that you normally take that you have not taken today?
no, ma'am.
How old are you and how far have you gone in school?
In third grade, I got my GED, college equivalent.
And what was the last part?
It was the college equivalent course when they changed it.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you're charged with the following offenses? In indictment 23 SC 191639, you are charged with possession of a drug-related object, giving a false name, address, or birth date to a law enforcement officer, driving on a suspended or revoked license, and possession of a firearm by a convicted felon.
Can you repeat the first one? I didn't get the first one correctly.
Drug objects. It's
didn't
just
know
an object that's used to.
It would be as simple as like a crack pipe is a drug-related object, or scales that are used to weigh drugs could be a drug-related object.
No, I didn't know. I got charged with that crime. That's
Do
what
you
I
need to
said.
see the indictment?
Yeah, I ain't seen nothing on my paperwork.
Okay. I can't do this. I need the indictment.
I have a copy. Yeah. Let me just triple check what the object was. You can have this. Oh, it was a scale.
No, I don't got no story, nothing.
So then why you taking free?
Because I know my record is not gonna look good. Period. If I even try to take it to trial, I got a long distance record. I ain't trying to go into detail. She claimed that they still charged him with the charge. I thought initially supposed to get trial, but they didn't even do that. He just charged me just because I was there. And I know if I take that to trial, I'm not.
Second indictment.
They gonna go off my history.
Okay. You don't even want to look at it?
I mean, I did, but at the time, everything I pushed back on, like I said, I don't want to take it to trial. I'm trying to negotiate the situation, period.
Okay, just 1 second. I can't do this. I don't feel comfortable.
Okay.
I can't do it.
No, you are technically capable of doing it, but I heard what you heard, which is Mr. Palmer saying it's the first time he saw the indictment.
And you've never seen this stuff.
Okay.
So, I mean, that's what he's saying. I don't know if that's the truth.
I don't know. I haven't been part of the Cabrera Palmer communication flow. But what we need to do, Mr. Palmer, is make sure you and Ms. Cabrera have a chance to sit down face to face. She shows you what's in the state's file. You're more familiar with the charges. I'm assuming you got arrested for this stuff, so you are remembering the incident. You and Ms. Britton must have been, I don't know if you were in a car or what, and there was stuff in the car, and you're charged with parts of it. She's charged with other parts. You're not charged with the gun. She is. So I don't know if it was like in her purse and not your bag, but we won't need to get into that. We need to make sure you and Ms. Cabrera have a chance to talk. So I think I'm going to do, just so that the cases move along together, since you and Ms. Britton are co-defendants on one of the cases, is that I'll just move your cases to the September trial calendar.
Yes, sir.
Means you need to come back here. More importantly, you're going to need to connect with Ms. Cabrera before you come back here. And partly that's on your lawyer, but partly that's on you. She's busy, you're busy. You're the one who needs to sit down and talk with her. She knows what your case is about. She could come in here and say, hey, you know, there was a confession, or it's on video, or whatever the situation is.
Right.
Do you have her phone number?
Yes, sir. To state, it's not that bad communication, nothing. It's every time I call her, she's been in trial.
Got it. Okay. I figured as you saw your trial date coming up, you're like, hey, we need to talk.
Yeah.
And she's probably saying, I'm stuck in trial. So then the right thing to do is for us to try this again. If you and Ms. Cabrera conclude that a plea is the right answer, same offer will stay open? Okay. All right. So Ms. Cabrera knows what the offer is. It's whatever you talked about, either with her or with Ms. Bumpus. And we'll just see what happens at the September trial calendar. Okay. Any questions?
No, sir.
Okay. See you around. Oh, I've got a question for you. Tell me your connection to Ms. Britton.
All right. So when I first met her, she done got put out the house. One of her friends that had passed away. So she the house she was at, she lost it. So everybody like put her out and everything. So she was in a hard situation. So I know me, I got a ministry and everything. I done started up since I've been home. So I let her come, and she was doing one of the past splits in the open houses. So, you know, when her friend died on the 10th of July of 24, I think it was, 23, we went over there to the candlelight vigil. And I can't really say anymore because it goes into my case.
Okay, and I didn't mean to ask you about the case, but you two, you know each other.
Yeah, that's it. She was when I met her, just like I'm helping her out, you know what I mean?
Yeah, okay. But you guys know each other. You're not related. She's not your cousin or anything like that. Okay, got it. All right. Well, we'll see you at the latest for the September trial calendar.
Yes, sir.
Thank you.
Thank you. Well, thank you for your time.
Well, I'm sorry, guys.
I mean.
No, don't apologize. Thank you for playing the role of a defense attorney.
Absolutely. Excuse me.
Maybe the Herald's on Edgewood closed. Yeah, that's what the lawsuit is about.
I didn't see anything on there about ice, only chicken, so.
No ice? I think the ice is if you go to the bar. I think that's their way of saying it's not just Coke products that we sell on the beverage side of things.
Judge, are you treating us all to Harold's Chicken one day for these long calendar calls?
Well,
Oh,
no,
it's
see, I
Gordon.
can't take-
It's Gordon.
Yeah, it would be Gordon. Since their lawsuit is in front of me, I can't be.
Okay, he-
I don't know if that'd be putting money in the pocket of the plaintiff or the defendant.
I think that's giving it to both, just
Yeah.
spreading it around.
I'm committed.
All right, is 3:20, and we struck out with Britton, we struck out with Palmer, we struck out with Bernard. What are we doing with, Ryder? Well, at least Lemons and Hardy and Robinson.
So I'm gonna be talking with, Ms. Bumpus, Mr. Regis, and Ms. Cabrera. And, there's potential for a resolution on Monday.
Okay.
Fine.
So, I should get ready for trial, for the four defendant case, with, I guess, Holiday as the backup, and then Rose. I'll send an email out. But what you see as a possibility, we couldn't go forward with Lemons, on Monday anyway, so we'd go forward with 3. But you're letting me know that, Robinson and, Hardy might not be going forward on Monday.
So that's very unlikely.
Okay, so then we'd be down to Mr. Ryder. Okay. Have you sent voir dire? You may have sent it like 100 times before, but just send it again.
Yes.
Okay, all right, great. And his clothes, well, it'll be in the email that I send out. Okay. Sounds like a plan. So I will see Ms. Bumpus and Mr. Regis and Ms. Feely and Ms. Wood here on Monday morning at 9. And we will, see what is still standing and have jurors ready for whomever.
Judge, at least, Ms. Bumpus and I come to a resolution, let's say tonight or tomorrow.
Huh?
Is it permissible that the court of Ms. Bumpus is to appear via Zoom for the plea on Monday?
I would like to say yes, but we've had Mr. Robinson get a little funky before when she wasn't around. And so I guess I just need some comfort that things would work out if you're not physically here, that I don't know how you're gonna get me comfortable, that Mr. Robinson is in a space where he'll go forward with it, even though you're virtual, as opposed to sitting next to him saying, come on, let's go.
Well, I mean, he wants to do it now, but for, reasons.
That you don't control, you
Yeah.
can't do it now.
And I don't, can I approach? Can we approach?
Okay.
I just don't want to talk in open court.
Okay, we can talk in a minute. Mr. Regis, anything on behalf of your clients?
Nothing beyond what's already been stated. I expect him to enter a plea on Monday.
Okay. Got it. Ms. Feely, anything else?
Not at this time.
Nope. All right. Then I guess that is a wrap for today. I will shut stuff down here and then we can talk about scheduling. Ms. Jackson, thank you for being here today. Appreciate your help as always.
Oh, no problem. Thank you, Judge. Have a great one.
You too. Take care.